In fact, I beg to mention item number 26 one, will file and rejoinder to the counter file by R4 and 5.
26
Yes.
on the prayer of Mr.
Number 4 and 5, Your Honor.
R.P. Sharma, learned senior counsel, assisted by T.Sham, learned counsel, M.S. T.Sham, learned counsel for the petition. Petitioner. 3 weeks time is granted, and as prayer not being objected to by, and as agreed to by learned counsel for the respondents, that this matter be listed after 3 weeks, so as to enable the petitioner to file the affidavit in reply.
Okay.
Pleasure.
0907
In the number is continue.
Yes.
May please, your lordship. This matter relating to compensation for wearing land. Matter was registered yesterday, and it was adjourned without our consent. So our price the matter will be taken up in the next week again.
Oh, I passed the order. How can we do that? Consent should have taken, but then
No consent has been taken.
what can we do?
After taking adjournment, they have informed us that we have taken adjournment. But
So how many years? How many days?
because
It has been adjourned for how many days?
I don't know.
You make a mention before.
We are not present. Item yesterday, item 15.
So it's very difficult now.
Yes, my lord. They should take our consent prior to adjournment,
But it's okay. We'll see.
my lord. Let the matter come up in the next week, my lord.
It's very difficult. Once we have passed the order, we'll have to modify it. You give the mention, not next week, after 2 weeks.
My lord.
After 2 weeks.
At least before
Yes.
vacation, my lord.
What's compensation? What's the, urgency? Land compensation.
Their land compensation. Before vacation at least, my lord. Huh? Yes. Not 26. It may be, my lord, 27 or 25. I will not be available on 26. 20.
Now you have to inform other side also.
Yes, I will inform.
Same thing will
Yes, sir.
apply to you.
My lord, with regard to item number 52, the petitioners would like to withdraw the matter, my lord.
52.
Yes, my lord.
Mr.
A. Roy, my lord.
A. Roy, learned counsel, but the petitioner submits that he has an instruction to withdraw this writ petition. Please tell accordingly, writ petition is hence disposed of on withdrawal.
I am obliged.
May it please, your lordship.
Yes.
Item number 20, my lord, 20.
Hmm.
I'm appearing as a legal aid counsel. I'm told some official respondents have filed an affidavit, although it's not there on record. In the meanwhile, could the matter be listed after the vacation? I'll obtain the pleadings if they have filed any and get back with what the
On the prayer of Mr. S. Banik, learned counsel for the petitioner. Learned legal aid counsel
legal aid counsel. My
for
lord.
the petitioner. Let this matter be listed after 4 weeks.
May I pray for a date, my lord?
It's okay. It will be listed after 4 weeks.
I'm grateful.
May the lordship, I beg to mention for listing one net petition, lordship, for motion, lordship. Lordship, this is very urgent matter, lordship, because PW department constructing a road by occupying my Merivata land, lordship. PWD department, lordship, constructing.
Next week.
Tomorrow, kindly, lordship, tomorrow.
Or next week. Next week.
Deeply.
May I please, your lordship?
Yes.
With the consent of the petitioner, I beg to mention item number 16, lordship. Lordship, in this matter, we will file our affidavit in opposition, lordship. For respondent number 3 and 4, lordship. We
Yes.
could not file it, lordship.
Huh?
We could not file the affidavit in opposition.
16, item 16.
16, lordship. 16.
So you want the
We will file our affidavit in opposition, Lordship. We need 2 weeks time, Lordship.
On the prayer of Mr.
As Paul on behalf of A. Bhattacharya.
As per on behalf of Mr. A. Bhattacharya, learned counsel for the respondent. Number
3 and 4.
3 and 4. Further 3 weeks time is granted to file affidavit in opposition.
Lordship, I am for the petition of.
Mr. So and so is present. Or the petitioner is present. Yes, please.
With the consent of the other side, I beg to mention item number 63 for adjournment.
63. Contempt. You are for petitioner.
Yes.
On the prayer, learned counsel for the petitioner, Mr.
S. Bolwe.
S. Boru. Huh?
S. Bolwe.
63. Your name is not there.
Yes. Is there, sir? Lordship. For the petition.
Oh, okay. List after 4 weeks.
May I please, your Lordship, with the consent of the other side, I beg to mention item number 1, 2, 3, and 4. Your Honor, the council is out of station, so the matter may be adjourned.
You are for applicant.
No, APDCL, respondent.
That's right. Applicant.
Yes, applicant in
Yes,
IAM.
I applicant in I.
1, 2, 3, 4.
Yes, Lordship.
Okay.
Let these matters be posted in November, my lord. I will be out of station.
As agreed to by the learned counsel for the parties, Mr.
SK Kejriwal.
S.K. Kejriwal and Mr.
C. Paul,
C. Paul, learned counsel for
APDCL.
APDCL. Let these matters be listed after in the month of November.
Public.
First.
May I please, your Lordship? May I please, your Lordship? Lordship, with consent from the other party, I beg to mention item number 5, Lordship. And I am for the opposite party.
Yes.
So we want to file the affidavit in opposition also.
What opinion? Yes, sorry.
Lordship,
Preparing for respondent in this case, Lordship. I am for the father and they are for the son, Lordship. In this case, under Senior Citizenship Act, I have obtained one eviction notice of the sons from my house, Lordship. In this case, stay was granted by this court. And then I have filed one IA for stay vacating, Lordship. In this case, they want to file reply. I have no objection if your Lordship fix any date on next week, Lordship.
Next week it's made on proposal.
Lordship, can it be on 19? Lordship?
19, Lordship.
It's only stay
After.
stay vacating matter, Lordship, in order column, it will come, Lordship.
Let it be after a week.
I
After a week.
I have filed after a week, Lordship, then next week,
Next week.
Lordship. Then can it be on 23rd, Lordship? It's a Monday, Lordship. 23rd, Lordship.
Mr. So and so learned counsel for the petitioner. No, in IA, huh?
In
I am for the applicant.
Okay, IA you are opposite party.
He is opposite.
Mr.
T. Borali.
T. Borali learned counsel for the petitioner. J. Borali or T. Borali?
T, Lordship. It is
T.
printing
Borali.
mistake there.
Learned counsel for the opposite party oblique writ petitioner submits that he may be granted a week's time to file objection to the IA. Mr. Prayer not being objected to by MS Archod, learned counsel for the applicant oblique respondents. Your respondents
Lordship.
in writ petition.
Yes.
Respondent writ petition.
One respondent,
Comma.
Lordship.
A week's time is granted to file affidavit, objection, file objection if any. Mr. A week's time is granted to the opposite party writ petitioner to file an objection if any. List on 23rd.
Lordship.
09.
Applies, Lordship.
Deeply applies.
Mention Lordship, item 24, Lordship. I'm going to put up 2 weeks, Lordship.
Why?
We are not prepared to the Lordship.
You are for respondent.
Petitioner, Lordship.
On the prayer of Mr.
J.M. Sulaiman.
J.M. Sulaiman, learned counsel body will list this matter after 4 weeks.
2 weeks, Lordship.
4 weeks. 3 weeks, 3 weeks. 3 weeks.
Lordship, I beg to mention item 51, Lordship.
Hmm.
This matter was last listed on 5th of this month, Lordship.
Hmm.
Since there is some urgency, it has been listed again today, and we were required to file an additional affidavit, Lordship.
Hmm.
Our affidavit is almost ready, Lordship. We'll file it today or tomorrow, Lordship. So I'm praying that it may just be passed over for today, Lordship.
After week, on the prayer of Mr.
Yes, they, Lordship.
as the learned counsel for the petitioner, list this matter after a week. Huh?
Most obliged.
Yeah, please, your lordship. Your lordship, with the consent from the other side, I beg to mention item number 39 to 40. Your lordship, we need some time to file our affidavit in opposition. Kindly, matter may be taken after vacation.
3940, yes. For on behalf of
On behalf of Mr. S.P. Roy,
Mr. M.S. Swenso, learned counsel appearing on Mr. S.P. learned counsel for the respondent number
6 to 31.
6 to 31. Further 3 weeks time is granted to file affidavit in opposition.
May I please, your lordship, lordship, I beg to mention item number 25. Engaged counsel has some medical issue. She recently had a baby, so this can be adjourned and fixed on next week.
Congratulations. On the prayer of Mr.
J.A. Sikdar on behalf of K. Jain.
My lord, the short date may be given because
So
nothing is survived.
counsel for the petitioner.
Next week.
Learned counsel appearing on me.
Respondent number 6.
MSK Jain, learned counsel for the petitioner that this MS Jain has some
Respondent number 6.
medical difficulty, medical issue. Therefore, praise for listing of the matter after 2 weeks.
My lord, 1 week, there is nothing surviving this petition after affidavit filed by the respondent.
See, your colleague is had
Yes,
a baby.
He's praying for 1 week.
Yes, ma'am, 1 week.
Okay, 1 week.
The date may be fixed.
1 week. It should be listed after 1 week.
Obliged.
May I please, your lordship? I beg to mention item number 66, lordship. Notice to the private respondent lordship already served on 26, lordship, as per office note dated 8/9. The Tagalog number has not been filed.
So,
Can you may wait for some days, please?
huh? On the prayer of Mr. Your
Our hope, Lord.
our Hawk learned counsel for the your name is there, huh?
Rabil Hope.
List this matter after 3 weeks.
May I please, lordship, I beg to mention for item number 13, 14, and 15. After 2 weeks, lordship.
13, 14, 53.
13, 14, 15.
Yes.
We have to file and reply in affidavit. Respondent
On the
number
prayer of so and so learned counsel for the petitioner, 3 weeks time is granted to file affidavit in reply. This after 3 weeks, huh?
May I please, lordship, I beg to mention for listing of great petition, lordship, land matters.
New matter
No, all pending cases, lordship, last posting of 12/2024.
after 4 weeks.
Right.
My lord, in this case, the petitioner, my lord, is certain amount is receivable by the petitioner under the liquidation process, my lord. The government have taken certain steps to deduction into. So some time may be necessary, my lord, for taking the process to its logical end. But we kindly give, my lord, some time, 3 weeks, 4 weeks, my lord. না সেইটো কাৰণে পইচাটো কিমান কি আছে এনকুৱাৰী এটা কৰিছে হা তাৰপিছতে পইচাটো ৰিলিজ কৰি দিবা ইনকুৱাৰী মানে কি তোমাৰ ৰেজিষ্টাৰ অফিচলৈ গভৰ্ণমেণ্টে লিখি পঠাই দিয়ে ফাণ্ড কিমান কি আছে কাৰণে হা নাই কোনে
You are still examining.
In fact,
Where was the last order?
Availability of fund, my lord, there should be some amount available.
In the event instruction are not so furnished, it is directed Secretary Corporation Department shall appear before this court online.
My lord, this is the
At 2
instruction. my
p.m.
lord. This is the instruction, my lord. Secretary, from the secretary, my lord. Comment of us, huh?
Heard Mr. So-and-so, learn counsel for the petitioner. By an order dated 0309/2025, this court has directed the, has granted the learned counsel, standing counsel to obtain instruction. Stop. Willing which the obtain instruction. Stop today, Mr. S.K. Talukdar.
SK Talukdar.
Learned standing counsel, Operation Department, by placing the communication dated 09/09/2025, submits that the respondents are examining the matter
Regarding fund, my lord.
with regard to the fund of the department, fund under state fed to meet the outstanding liabilities of the petitioner. Therefore, he prays that matter may be, sometime may be granted to examine and examine the matter by the respondents, examine the matter and to bring it to its logical conclusion. Let's to consider the above. Further, 4 weeks time is granted to the respondents to examine the matter and to bring the matters to its logical conclusion, as the amount appears to be, as the claim of the petition appears to be not disputed. This after 4 weeks.
If I may pray for a date, my lord.
4 weeks, we'll see. It will be listed.
May I please?
Yes.
Can the matter be passed over for timing?
Why?
Actually, my senior is on late.
Why any affidavit has been filed? Pleadings are complete.
Yes, my lord.
What is the stand? There's no affidavit. Affidavit is there. Affidavit is not there.
My lord, and I understand, my lord.
May I please, your lordship, item number 7 and 9 can be disposed of.
Why?
His lordship, what has happened, they have, the state government have issued a notification in our favor. A circular has been issued. May
My lord,
Can
let
you
us
please to
take
place
up
the-
about department in this matter.
Lordship, I think so, no, they have no role to play. The demand is by IOC.
Hmm.
I have challenged the demand from IOC, not from the state government.
Hmm.
They have no role to play in this case.
So,
Lordship, they have issued this circular.
what circular?
Lordship, this circular has, because Lordship, the demand by IOC was in pursuant to a circular.
That circular has changed.
The circular, Lordship, they have superseded the circular and issued the circular in my favor.
So nothing remains.
Nothing remains so far as item number 7 and 9 are concerned.
So you will close it
To these two matters can be closed, Lordship, and the demand, whatever is
in view of the issuance of the circular.
Yes, Your Lord.
We'll just close it.
7 and 9, Lord.
Nothing, no recording of the facts.
Lordship, only that the demand may go because because of the new circular, the demand by the IOC may go. Demand which has been issued by the IOC, they have issued a demand to me.
No, once they, yes, do you agree?
My lord, my senior appears for item number 8, and the prayer which was sought in item number 8, that circular has been set aside, my lord. There's an order of this honorable court.
Lordship, I will come to item number 8 for afterwards. Lordship, let
This
us-
is 7 and 8, 7 and 9.
I do not appear for 7 and 9, my lord.
Let our department standing counsel appear in this matter, my lord. The matter may be disposed of, my lord, but in front of me, my lord.
7 and 9.
7 and 9. Lordship.
You share this, what this circular says?
Lordship,
Liability.
it says- Lordship, the demand was raised only because I gave a C form. Once I give a C form, my rate of tax will be 2% instead of 23.66%. Now because of one circular earlier, 5th of September 2017, which is the subject matter of this writ petitions, Lordship, the state government had issued the circular saying that no, you cannot accept the C form. And so 23.66% tax has to be deposited. Now this circular, Lordship, they have issued because Lordship all over India, even central government have issued notification that that position is not correct. State of Assam is wrong. Therefore, Lordship, the new circular which has been issued, they have asked the state government to accept my C form. Once C form is accepted, Lordship, my 2% tax is only levied, not 23.6.
Where it is that your C form shall be accepted?
Lordship may kindly see 9th of August 2018, the circular which I have given, the point number 3 at the next page.
Declaration form C for the periods executing from 1st of May shall be issued
Purchase.
only if such goods are purchased for the purposes of issued by Minister of Finance.
Resale of the six goods, manufacturing of 6 goods, and 3, use about 6 commodities in telecommunication network or mining or generation or distribution of electricity. Lordship, I fall under 3. Lordship, what had happened?
Use of 6 commodities
Yes, Your Lordship. Lordship, the
in the
commodity.
telecommunication network and mining or generation or distribution of electricity or any other form of power. Yes. What is this? Do you agree?
7 and 9, Lord.
My lord, so far as the, my lord, June circular is concerned, 5/9/2017, that has been interfered with by the honorable court. So the main relief is already, they will get the relief.
So, Lordship, the 7 and 9 can be set aside. You know this.
No, once that has been interfered with, what more we can?
Yes, that's why I'm saying.
Same circular.
Same circular. No,
So, Lordship, 7 and 9 can be interfered with and maybe.
no, subsequent to that, new circular has been issued by the.
Circular, which is in my favor.
Then Lordship will see, my lord, while disposing of the repetition, since my lord, the circular has been interfered with by a coordinate bench. Lordship will say, my lord, whatever is due otherwise, since the circular is not there, the authority will look after that.
7 and 9 can be, Lordship, this is not issued by any authority. This is issued by IOC. The demand has been issued by IOC. So, Lordship, IOC has accepted the fact that yes, now no longer the demand is there. I am only saying this for 7 and 9, Lordship. Item number 8 is a bit different. I'll place my arguments for item number 8 in a different way. 7 and 9, Lordship, can be disposed of. The demand from the IOC, because the circular has been interfered with by this honorable court, pursuant to which demand has been issued by IOC, and new circular also has been issued by the state government, which is in my favor. So, Lordship, pursuant to this, the demand by the IOC may go away, Lordship. 7 and 9. I'm not challenging anything relating to state government so far as 7 and 9 are concerned. 7 item number Vijay Nirman, or 9 so to demand by IOC, not by the state of Assam.
This circular 0509/2017. Where it is?
Lordship, it is there in the requisition. Lordship, may kindly see the page number.
4917 is the page.
Lordship, page 96. Lordship, no, reference to the which he can no. Lordship, may kindly see page 52. Item number 7, page 52. Yes, Your Lordship. The
0509.
2017.
Yes.
Lordship, paragraph 9 is the relevant portion.
No, this has been set aside.
Yes, Your Lordship. Set aside, even the state government has thereafter issued a circular superseding this circular.
One.
Yes, Your Lordship.
So what remains?
Nothing remains, Lordship. So the demand.
Nothing remains, we'll just close it. Become infructuous.
No, Lordship, not infructuous. The demand may go. The demand has been issued pursuant to this circular. Lordship, may kindly see the demand which is at page 50 by IOC, not by state government.
No, this this demand is based on not this circular.
Only on this circular.
Then,
so this
if
it is not set aside.
If the foundation is removed,
yes, Your Lordship.
automatically superstructure falls. We'll say infructuous.
No, Lordship. At least this is not linked purchase, Lordship. This may be set aside.
The circular, the demand issued by the IOC is based on this circular, which has already been set aside.
Yes, Your Lordship.
Then the new circular has been issued.
They have not taken back their demand. They have not issued any letter that now.
How can they demand now when the circular is set aside?
Please least they can issue a letter that we no longer demand this. The demand remains, Lordship, unless and until this court interfere with the demand. The Lordship may kindly observe only one line that the demand no longer stands in view of the new circular and the Lordship, the
So this item
7 and 9.
same,
Lord, 7 and 9 are same.
facts are different.
Lordship,
Demand same date.
demand is the dates are different. In this, Lordship, the demand is 9th of January 2018. Item number 7. Item number.
Where is the demand?
Lordship, the demand is at page 50 in item number 7.
One by one, madam. Don't rush. 50. This demand is by whom?
This demand, Lordship, is by the IOC, Indian Oil Corporation.
Okay. Heard MS. So we'll close it.
Yes, sir.
And how will you learn counsel for the petition? It will be separate order, huh? But almost the same order. And Mr. Bigo, learned additional. You'll be a standing counsel or additional advocate general?
Standing counsel.
Standing counsel? Huh? Standing counsel,
Finance and taxation department.
Finance and Taxation Department. And MS so and so for IOCL. Your respondent number? 3. For state respondents and so for respondent IOCL. Challenge made in this writ petition is to the circular number 7/2007, dated 05/09/2017, and the demand orders issued by the IOCL, respond number 3 and 4. Whereby the statutory C form issued by the. This is your government of Arunachal or what?
No, Your Lordship, the government, I issued the CFROM from the Arunachal Pradesh to Assam. Assam must accept it, then I will get a concessional rate of tax.
For CST, under CST and grant concessional rate of tax. Your C form has been rejected.
Lordship, C form has been rejected.
Is rejected. List of the petitioner is a registered dealer under the Central Sales Tax Act 1956, and the registration of the petitioner who has registered, registered dealer under the Central Sales Tax Act. By the circular dated 05/09/2017, issued by the Commissioner of State Tax, Assam. the grant of concessional rate of tax on production of C forms in respect of sale of 6 products has been denied, which according to petitioner is contrary to the express provisions of law as well as the impugn and also the impugn differential demand raised as a consequence thereof by the respondent IOCL being unjustified and in violation of principle of natural justice. It is stated at the bar that the impugn circular dated 20/7/9 05/09/2017 has been set aside by the coordinate bench of this court in the case of Star Cement Meghalaya. And in the case of Star Cement Meghalaya, WPC 366 of 2018 by an order dated 04/09/2018. Thereafter, consequent to the setting aside, the respondent authorities has issued a fresh circular number 12 of 2018 GST dated 09/08/2018.
Lordship may direct the respondent number 3, that is my IOC, to now proceed as per this new circular. They will do the
Which internally provides that declaration in Form C for the periods starting from 1st of July 2017 shall be issued only if such goods are purchased for the purposes enumerated in office memorandum issued by the Ministry of Finance, Department of Revenue, State Tax Division, dated 07/11/2017, such as use of above 6 commodities in the telecommunication network or mining or generation or distribution of electricity or any other form of power. It is fairly submitted by the learned counsel for the parties that in view of the new circular, no adjudication is required in the present proceedings. New circular dated 09/08/2018. No adjudication. And there is nothing to be adjudicated. And nothing remains to be adjudicated in this proceedings. Therefore, next, having considered that the impugn circular dated 05/09/2017 issued by the state respondent, having been set aside by this court and by the coordinate bench of this court in the case of Star Cement Meghalaya Supra, and thereafter another circular, thereafter a circular dated 09/2018, 09/08/2018 has been issued by the Commissioner of State Tax, Assam, providing the benefits of concession in Form C I deem it appropriate. I am of the considered nothing remains to be determined in this proceedings list of accordingly the writ petition stands closed. Is this disposed?
Demand or not this?
It is, I will say, it is needless to observe, no, in view of the setting aside of the circular dated 05/2017, the, what demand?
Lordship, the
Different-
page 50.
What is this demand?
The demand is by IOC, Lordship, to.
No, what do we call it? Differential tax
Differential tax, huh? Differential tax. Lordship.
demand by the IOCL
Yes,
on the basis of the circular dated 05/09/2017. Is known is states is set aside.
Set aside. Lordship. Yes, sir.
What is that?
Yes, sir. Lordship.
Circular was set aside.
Set aside. No, this demand, differential tax.
No, Lordship will say, well, now they will proceed as per the new.
No, that's
circular.
will say,
Yeah.
the differential tax so and so demand by the ISL is set aside. However, the ISL, the respondents may proceed with the respondents are at liberty to take initiate
Yes.
action in terms of the new circular, the fresh circular dated 09/08/2018.
The same will be item
The-
item number 9.
The copy of the circular so and so, 09/08/2000 is kept on record.
So same will be item number 9.
Let us see item number 9. Vijay Nirman,
Yes, sir. Lordship.
demand is,
At
you
page.
just say the demand at page 50, item 7. Differential tax demand so and so, dated, so and so. You find out the date, page 50. In item 7. Yes, this is same.
Yes, sir. Lordship. Same.
Demand is
At page 45.
45.
At page 45, it continues. Lordship.
Page 45.
46, 47.
What is the date of demand?
Lordship, at page 46. Lordship will find.
Page
Lordship, the
46.
date is not exactly mentioned. It's continues, Lordship, until.
No, page 46.
Page 49. It continues up to page 49, but the date is not, Lordship. Continues up to page 49.
There is no date.
There is no date. The demand may be, Lordship, the demand as well
Demand
as
so and so.
maybe such. Okay, so far as item number 8, Lordship is concerned. Lordship, now this is a bit different than other cases.
So,
Even though it is similar, but over here, Lordship, what has happened? That so far as this case is concerned, from the very beginning, the central government, because Lordship, CST is relating to central government. The central government has issued the circular from the very beginning in our favor. Because I deal in mining, Lafarge. Lordship, what had happened, Lordship, they have collected taxes from the year 2017-18. 2017-18, IOC has collected taxes and paid to the state government. Now, Lordship, for the future period, from the period 2018-19, they have accepted the judgment as well as the circular. But for the period before that they have collected, the IOC has collected and deposited in the state government's coffers, the affidavit has also been filed that so far as that period is concerned, the court has to decide what has to be done in the matter, because the now amount has gone to state government. So, Lordship, the amount which is there, which has been deposited in the state government coffers, has to be refunded back to the IOC, and IOC will have to be refunded back to me. Lordship, in their affidavit, the IOC has stated that they are only an intermediary. They are nobody.
it's okay. How you are, what is your right to be right to get refunded.
Lordship, I'm going to get more than 1 crore of rupees
Oh.
for 17-18.
Why?
Because 2% of tax, because I have given C form to IOC. So once I give C form to IOC, my rate of tax should be 2%. But they have not accepted my C form in view of the circular. But when the new circular came, they have to accept the C form. So thereafter, they have taken 23.66% of tax from me. Instead of 2%, 23.66%. So 21.66% tax they have collected extra from me in respect of these products, which are the 6 products which are left after in VAT Act. So Lordship, the amount has been collected and paid to the state government. Now Lordship, there has to be an adjudication from this court. They have filed an IFC has filed an affidavit specifically in this regard that the court has to decide what will happen to that amount. Because the circular now has superseded the earlier Lordship circular.
No, the collection, I mean, the imposition of tax was earlier to that, earlier to the
Lordship,
prior to the circular.
but circular Lordship, as your Lordship knows, that circular is from retrospective. It is not prospective. Circular is only the interpretation of law. What is the law as on today? So Lordship 17-18, the interpretation was wrong. They have accepted their own. They have accepted the mistake. Because Lordship, the central ministry and all over India, Lordship, I have annexed all the central ministry circular from the very beginning. From the year 2017 itself, they had issued circular. There was a confusion that what will be the rate of tax, whether they will, because GST has come into being. So they said that now VAT and CST is no longer there. We should not accept C forms. But Lordship, VAT is surviving for 6 products, petrol products and whiskey. So Lordship, those products, 6 products which are still in the VAT, they are the VAT is surviving for those 6 products. So I have to get a concession rate of tax by giving a C form. So the law was very clear in all over India, but there was a confusion in the state of Assam and 1 or 2 more states in the all over India. The central government had made it very clear from the very beginning that the rate of tax will be 2% if you give C form. And C form should be accepted. State of Assam issued circular, no, we will not accept the C form. Because you are no longer a dealer. And therefore, they issued the circular in paragraph 9. They have mentioned very clearly, we will not accept the C forms in respect of these 6 products. Either you purchase and sell the 6 products, I will accept. Otherwise, I will not accept. If you use it in mining. Now, Lordship, central government circular says, no, in mining also you have to accept C form. Now, Lordship, thereafter, they have themselves issued circular that my earlier circular was wrong. I superseded. And now I am saying that yes, even for mining also, I should have accepted C form. So they have now applied that from the date of notification, they have applied this. But before that, the amount which has been collected, that was also wrong, Lordship. Now, Lordship, they are not making anything clear. They have not refunded the money back to the IOC. IOC has not refunded the money back to me. This is the position which they have made clear in their affidavit also, that I am just an intermediary. If state government will refund, I will refund it to you.
Yes.
So
What is the state of the your
In
Your
this particular case, my lord, let them submit the application for refund. And my lord, the authorities will consider as per the new circular, my lord, since we have superseded.
Lordship, I have
only
paid to
that part.
IOC. I cannot file a refund application. That is they know that. I cannot file an application because I have paid to IOC, not to them.
They will apply before the IOC will correspond with the department, my
They
lord.
cannot. IOC has made this stand clear in their affidavit. They cannot, Lordship, because
they can refer it to the bank.
Yes.
I mean the state government.
Yes, Lordship will refer it to the state government. As per the,
Lordship,
our circular, we will decide.
Lordship, in the affidavit that IOC has filed, they said I am just an intermediate. The court will decide that what has to be done in this.
No, you file an affidavit. They'll consider in view of the new circular.
Lordship, but I have not paid to the state government. How will the state government refund it to me?
You apply to the IOCL to whom you have paid.
We have given hundreds of letters.
And
They will correspond to the.
That steps have already been taken. They have not refunded. I have given letters to the thing. They are all waiting for the judgment of the
Because of the pendency of this petition, it has not been done. Lordship will clarify by
I can place Lordship hundreds of letters I have given to IOC as well as State of Assam. State of Assam says no, IOC should come. IOC
yes.
Punish an application or an affidavit to us, we forward it to my department, my lord. In fact, we have stated that there is no other role for IOCL in taxes which have been levied. But we have to follow the rules and directions to the state of Assam.
But you are the one who has collected.
Yes, ma'am. File an application for us.
We have filed hundreds of applications before that. They have not refunded it.
Yes, Lordship will direct, my lord. Now, all the respondents will act upon.
In the meantime, we will do it. Otherwise, they will never refund.
There was a stay, my lord. There was a stay.
There was no stay, Lordship.
11/4/2018.
The order says that don't collect more than the differential tax for the future period. For the past period, nothing was done.
Heard MS so learned counsel for the petitioner and also heard Mr. B. Gover, learned standing counsel for Finance and Taxation Department, Governor Bashram, and Ms. M. Sharma for IOCL, learned counsel for the respondent IOCL. We'll just adjourn the matter, and in the meantime, you may file application.
During the hearing, Lordship, we keep it partnered. In the meantime, we will do the.
What part hard? No part hard. Or we'll dispose it today, we'll direct you to apply.
Lordship may kindly, it will not be a bar. Lordship may kindly give us liberty that it will not be a bar that we apply before that. In the meantime, we will do this.
As agreed to by learned counsel for the petitioner, let this matter be listed after 4 weeks. In the meantime, in the meantime, considering that the state respondents has already issued a circular that is 09. What is that?
0908/2018.
0908/2018. Not in the meantime, considering that the state respondent has already issued a fresh circular dated 0908/2018 with regard to the concession. What is tax concession?
Yes.
Concessional tax. Under the in Form C declaration, the petition, the pendency of writ petition shall not be about to approach the authorities seeking refund of the tax already deposited, the tax already paid prior to
9th of August 2018.
will not say already deposited. Tax already paid. This after 4 weeks.
May I please, Lordship?
Yes.
In this case, my lord, the honorable court by order dated 20, my lord.
Yes, you did appear.
Matter was sent to the mediator, my lord.
You have not appeared.
My lord, but my lord, the petitioner received the notice after expiry of the date of my lord appearance, my lord. They received the
Heard
notice.
Mr. So-and-so learned counsel for the petitioner and Mr. J. Hendrik learned state counsel and as well as M. Bhattacharya, A. Bhattacharya, learned state counsel for all the respondents. Both of you are for all the respondents. For respondents, huh? This matter was only as agreed to by the parties. The matter was placed before the coordinator mediation center, Guwahati High Court, for resolution of the issue by mediation. Next paragraph. A report of the mediator dated 29/08/2025 indicates that the mediation has not started due to non-appearance of the parties. Mr. As submitted by the learned counsel for the parties.
For petition.
It is directed that the parties shall appear before the mediator. When?
On 23, my lord, they have received the notice. Date was fixed on 21/8.
Next, no, it's not fixed.
Date not fixed. Directly send the report to send it to the court.
on the next date fix, list of the mediator to issue notice to parties.
Hello.
And then you write thereafter, report be placed before them. Report be placed, after, we'll say, after 3 weeks.
Lordship, kindly pass over for timing, Lordship.
Item
Conducting council lakhs.
11 and 12 is what? What is this?
Lordship, conducting council is on lakhs, Lordship.
Matter is related to eviction, Lordship. They were constructed in government land, Lordship. But they are saying that they are in Patta land. But as per our affidavit file in WPC 794 of 18, Lordship, they are constructed in first government land. So we have not eviction notice. In this case, stay order is operating, Lordship, and they have obtained permission for construction in their landed property, which is Patta land. But some portion, I think, as per our affidavit, it is government land, Lordship.
Where it is? Where is your
Affidavit filed by the BTC, Lordship. Page, Lordship.
In which case?
Lordship, 1 minute. Case number 7, WPC number 794, we have filed affidavit. Running case here not given, Lordship.
794.
Yes, Lordship. Affidavit filed by Robinson Musahari.
There is no record. No affidavit has been filed.
No, the second case, Lordship. Older case, Lordship.
Second case is.
Two case, Lordship, here. Two read petition. Take together.
794.
Yes, Lordship.
Lordship, after some time.
794, affidavit filed by respondent number 2.
The same area.
Same area, Lordship. I think adjacent. I think adjacent plot. Because we have filed affidavit stating that paragraph 5. Respondent illegally constructed. Respondent states that the petitioner illegally constructed house over the PW government.
Robinson
Musahari.
Musahari.
Yes, Lordship. Paragraph 5.
As a report,
Illegally
the petitioner constructed house over the PW government cost land.
And paragraph 9 also. Petitioner was occupied government cost land along with Patta land.
Eviction was done for illegal.
Along with Patta land.
So Patta land to no issue.
No issue.
What is the area? Is there any specific area?
Lordship. Since they are disputing, let them approach appropriate forum, Lordship.
After some time, we'll see.
Lordship. 17. So item 17. Oh. And 18 also. Lordship, this is regarding on last occasion, the Honorable Court had asked the PTC regarding to bring into record the particular fact that whether this writ petitions supply order is covered under that particular scheme, which has been already they have stated in their affidavit. So in that matter, they have filed an additional affidavit, and we have come to know that on 5/9/2025, a committee has been constituted.
Yes.
And now whether it is constituted or not?
Yes, later on it is possible.
So the fact remains is that within 3 months, this matter will be taken care of by that committee, which has been constituted. So if in that regards, we do not have anything to say. Only the fact is that the exercise should be done in an expedient way, since it is an admitted outstanding bill amount and already 21 matter. So if the supply of the fact remains is that if the petitioner is eligible for that amount from the BTC, then he should be paid that amount.
Are you disputing?
No,
Are you disputing?
they are
Because-
disputing, so.
Because lordship, supply orders, beyond lordship, SOPD comes.
Huh?
Lordship, earlier affidavit we have stated, claim of the petitioner is, claim of liability is 499.16 crore from the supply orders issued by them in between 2010 to February 2020. It is stated that as per office record, out of total administrative approval amounting to rupees 718.86 crores, surprisingly, only 396.30 crore was permitted for all orders. And to the others of and surprise, Salan value against the said of orders was found to be 457.3 crores, exceeding total of orders value. It is to be stated that those supply orders were issued beyond the AOP public SOPD fund allotted against the financial years. Therefore, BTC Executive Council decided to inquire the matter through state government, but state government issued letter to the BTC that BTC own can do this. Therefore, we have constituted a committee and decided to complete it within 3 months, Lordship. And committee has been constituted, Lordship.
So basically, your lordship.
We'll dispose of the matter. Let them verify. Since they have already completed the,
Yeah.
I mean,
But our own contention is that within that period from 2010 to 2020, this particular amount has been shown. So now since they have already stated that our supply orders are also included, like amongst the total corpus, like the total amount which they have mentioned, like which is also certain.
no, see, these are, you are claiming for payment of the bill.
Yes.
Now, unless it is admitted, we cannot pass any order.
This is an admitted
No,
pay.
No, it's not been admitted.
Therefore, we are inquiring.
So since they have constituted a committee, which
Authorities
they,
have
which they
endorsed
have
already.
huh?
Authorities have already endorsed in the writ petition. We have seen that the authorities, the competent authorities at that point of time. But now, since they want to have that exercise, we do not have anything to say on that. We are
So-
not, yeah. Only the fact remains is that
There's no only facts. Facts are disputed. Right?
yes, my lord,
Heard, Mr. Will dispose of the matter.
my lord.
Heard, Mr. So and so,
WRVD.
learned counsel for the petitioner. And also heard MS Arbi Bora, learned standing counsel. What?
BTC.
BTC. Respondents BTC. Record their name. Next para. By filing this writ petition, the petitioner has read for a direction to pay the admitted outstanding bill amount of ₹50 lakhs to the petitioner on account of what is the work? What is the work you have?
This is a supply orders.
What supply order?
LED lights.
Where you have mentioned?
In the cost title it is there, my lord.
What cost title? You body of the title, writ petition, tell us.
621. It is regarding 50 lakhs work order, formal work order allotted to the petitioner by the respondent authorities.
Where it is?
Page number 2. That in the cost title, lordship.
What cost title? You tell us where is the work order?
My lordship, in the index sign.
You are not ready or what?
No, lordship, actually my main brief was with my junior, it was left. I got the affidavit, lordship.
For installation of work
Yes.
of installation of street light at TP Road, Gosaigaon town.
Under the 5th Assam State Finance Commission for the year 2019-20.
For an amount of rupees. No. For the work of installation of street light at TP Road, Gosaigaon town. BTC,
Annexure F, page number 27,
cockroach.
Lordship.
I have seen it already.
Lordship.
List of the this is pursuant to the tender.
Yes, my Lordship. The tender is
It is the case of the
page number 23, Lordship. Annexure D.
that pursuant to the tender NIT. Where is the date of the tender?
Date
Tender 0401.
4th of January 2020.
Issued by the CHD Urban Development Department, BTC Cochrane, the petitioner was for installation of street light at TP Road at Gosaigaon Town under 5th ASFC for year 2019 to 2020. Page 25, huh? Page 23, NIT, huh? The petitioner was issued with formal work order dated 21/01/2020. For the installation of street light at TP for a total price of rupees 50 lakhs. List of accordingly, the petitioner executed the work in terms of the work order. List of Mr. So-and-so, learned counsel for the petitioner, submits that despite the satisfactory completion, execution of the work in terms of the work order issued by the respondent authorities, the respondent authorities have failed to discharge their liability of paying the admitted outstanding amount of rupees 50 lakhs to the petitioner. Petition despite several approaches, huh? Despite several approaches. Are you getting? Am I clear? Am I clear? Therefore, he submits that the respondent authorities may be directed to release the admitted outstanding amount of rupees so and so to the petition. Next para. MS RB Bora, Learned Standing Council, BTC. The submits that although the respondents have not admitted the claim of the petitioner, the payments to the contractors are subject to fund released by the competent authority and the government of Assam to the BTC authority. She submits that BTC authority has decided to conduct an inquiry into the supply items provided by all the contractors, including the writ petitioners. And the report of the committee has to be submitted within 3 months from the date of constitution of the committee. In view of the fact that there are many contractual works, there are many claims by the contractors for the works pertains to 5th Assam Finance to Assam State Finance Commission for the year 2019 to 2020. The state has the BTC authority has already constituted a committee by notification dated 0509-2025, whereby the BTC, whereby one Siri Ashwini Dole, ACS Secretary, BTC, Cochrane, has been appointed as inquiry officer in order to inquire into the claims of the contractual payment pertaining to the writ petitions, including the present writ petition. Therefore, she submits that in view of the appointment of inquiry officer, it would be appropriate to complete the process of inquiry by the BTC authority. Next page. Having considered that the BTC authority has constituted a committee. It's not a committee, it's an inquiry officer conducting some to decide to conduct an inquiry, constituting. No, it's okay. Next point. Having considered that the BTC authority has issued a notification dated 0509-2025, appointing an inquiry officer to inquire into the claims of the contractual payment pertaining to the writ petition, including the present writ petition, I deem it appropriate to dispose of writ petition with a direction to the responding authorities to expedite the inquiry as notified. This stuff. That's all. Expedite the inquiry. This stuff.
Within that particular time period.
No, expedite, we'll say expedite. On inquiry. No, expedite the inquiry and verify the claims of all the claims of the petitioner. List of. Accordingly, this writ petition, no, accordingly, it is provided that the BTC authorities shall expedite the inquiry and also verify and inquiry and to verify the claims of the petitioner within a period of, you said?
We have said 3 months.
Within a period of 4 months from today. In the event the petitioner is petitioners or petitioner?
One petition.
Petitioner is in the event if the claim amount of the petitioner is found to be admitted, same shall be released to the petitioner. If he found to be
Yes, yes. Subject to the
within a further period of 3 months.
No, no, Lordship. We are following terms early because paucity of fund also dear Lordship. So we cannot pay within 4 months, Lordship, if they are eligible also, Lordship.
Yes.
Our hands are tied, Lordship.
Then we'll say, we'll say
Following terms early, Lordship.
paid to the petitioner following the principle
Later.
laid down in the following the terms, principle laid down in the full bench decision of the decision in Tamsir Ali so and so. What is that reported in so and so, huh?
I shall give.
Read petition instance
Lordship,
disposed of.
item number 18 also same, only
Same.
amount is 37 lakhs 50,000 here.
Ah.
And the work order is a separate work order.
Page
27.
Page
Annexure H. That is the work order.
same tender.
Yeah, not tender is same only.
Tender same tender.
Yes.
You
Tender
say
4th of January 2020. Yes.
Tender same. Page
22. Annexure C. That is the tender.
second
Second one.
page 22 tender, huh? And amount work order
27 page number. Annexure H.
Annexure page 27 same date.
Date
Date of work order is same.
Work order date
What
is different. 5th February 2020.
5th February, huh? Work is same.
Yes,
Is
work is same, but it is now it is at Tongla town.
Tongla town, huh?
And amount is 37 lakhs 50,000.
You check out from that. Work order, you find out work order, the amount and everything is the same. Huh?
Lordship citation is 2008 for GLT 1.
2008 for GLT, you said?
Page 1.
2008, huh? Within bracket 4. Bracket close. GLT 1.
My lord, in this case, for respondent number 9.
So what do you want to say?
In this case, main is my lord petition.
So record has his name also. Record his name. Your name, please. M. Hussain for respondent number 9. Land Council for respondent number 9.
Oblige, Lordship.
Dispose of.
May I please, your Lordship?
Yes.
Lordship, today we have filed our rejoinder, Lordship.
So
Let the matter come up after 2 weeks.
I will respond number to your Lordship.
Mr. M.S. So Land Council for the petition submits that she has filed the affidavit, the affidavit in reply
Yes,
today.
Lordship.
List of
Essay Riasan.
association is present, huh?
It's one number 2.
In view of registry to verify and take with the record, list the matter, as wait for list the matter after 2 weeks.
You're obliged. In this case, yesterday we have filed an affidavit Lordship. This is not a record.
Not on record. What is the matter?
Matter, my lord, my mall, my lord, was demolished within 24 hours, my lord. So, when my lord demarcation was made, my lord, on that very date, I approached this honorable court and of course, this honorable court has grand interim order staying the eviction, my lord. But when the interim order is in force, my lord, on that very date, they have demolished.
So nothing remains. What is the land?
Patta land.
Patta land?
Yes, with due permission.
Yes,
Therefore, my lord,
it's a Patta land. Huh?
and this honorable court was the truth that because my 35 lakh has been damaged, my lord, for construction.
35 lakh?
Yeah, therefore this honorable court was of the view that some compensatory.
Affidavit Lordship.
Affidavit is there.
A date may be fixed, my lord. That record is required, my lord, because some clarification is required. Not required.
What clarification?
Because, my lord, they have in their
Affidavit Affidavit filed by the petitioner. Affidavit in opposition by respondent number 8 and 9. Yes.
Kindly see order dated, my lord.
Heard Mr. So-and-so, learned counsel for the petitioner. It is submitted by Mr. N. Goswami, learned counsel for learned state counsel, that he has filed the affidavit in opposition on behalf of respondent number 2. Who is respondent number 2?
Deputy Commissioner. Deputy Commissioner Hasan.
Deputy Commissioner. Respondent 2. Mr. Harbour. Same is not placed with the record. Placed of registry to verify and place that affidavit in opposition filed by respondent number 2 with the record. Next paragraph. Have you received the copy?
Yes, yes. Yesterday.
Mr. So-and-so is granted liberty to file reply if so advised.
Published.
23. These two cases complete instruction is awaited. Lots will fix it after vacation, my lord. In the meantime, with the instruction, I will file the affidavit.
Heard Mr. A.K. Roy.
I go by.
Oh, sorry, I go by.
Yes.
Learn counsel for the petitioner. Well, only in the same matter.
Both are same.
Both are same.
Both are same.
It is relating to land acquisition.
Okay. For the petitioners, petitioners. Single, it will be one order. Separate order is required, no?
No,
In 21. On the prayer of Mr. S. Bora, Land Council.
GMC Lords. GMC Lords.
Standing College GMC. Further 3 weeks time is granted to obtain instruction and file affidavit in opposition. Just after 3 weeks.
Mass oblige.
Well, we have already filed an implement petition in this case for impleting for
So,
that was not listed before this one. Not listed today, my lord, the IA.
Mr. P.J. Sekhe, Land Counsel by the petition, submits that he has already
He has filed on 26/8, my lord.
he has filed the he has filed an interlocutory application for seeking implement. Mr. However, same is not placed on record. Same is not tagged with the record.
Yes.
There is registry to verify and take the
Our affidavit is filed also. Our affidavit is filed also.
take the file, take the IA with the records.
Next Monday, my lord, maybe fix my.
Mr.
Sorry.
N. Goswami and A. Bhattacharya, Learned State Council have submitted that they have filed their affidavit in opposition. List the matter. On 19th.
28.
Wait, please, Lord.
Yes.
Lord, here, Lordship has directed us to obtain instruction as regard whether the enquiry report has been given to the petitioner or not. Lord, in paragraph 29 of the petition, there is a report by the executive engineer PWD building as regard the condition of the petitioner's building, dated 15/9/2023, and that information is required. I have received the information, Lord. In fact, the report was
So
that report was not, my instruction said it was not given furnished to the petitioner. Yes,
you furnish now.
No,
I have given a copy.
issue is something
I have
different.
given a copy, Malad.
Why your lordship has called for this instruction is because of the impugn order.
Appeared for the respondent for the insubordinate registry to this matter.
Well, what has happened,
whether the report of the executive engineer relied upon by Deputy Commissioner for drawing conclusion the matter is furnished before hand to the petitioner. Yes.
My instruction is that it was not given to the petitioner, you have not furnished.
Therefore, my lord,
We
the
have given a
impugn
copy.
order has to be set aside.
No.
Because therefore the
I have my
impugn order
submission.
has to be set aside, my lord.
Huh?
Therefore, the impugn order has to be set aside.
What is impugn order? Let us see.
Page 77, my lord. Thank you.
Yes. Whereas the prime incident took place at honest commerce system located in the country and this is the same day, 15-9.
Yes.
59.
The deceit commerce system was unsafe and dangerous. Report of what? PWD.
Well, may I indicate to your lordship, please? What has
Whereas
happened
based
was,
on survey report of the private firm engaged by Arun the 15-9. Yes, that has not been furnished to you.
yes.
So,
Therefore, my lord, that order is become a non-est. Why, my lord? Because in earlier round of litigation, what has happened, my lord? My building has, my lord, caught fire. And, my lord,
Dubeji,
my lord,
you are, we would like, whether this has been furnished to you or not, that was not furnished. Now you are furnishing. What do you want
my lord,
to say?
that decision, impugn decision is based on this report, which has
Yes.
not been furnished in spite of direction by the High Court. So, my lord, they have taken into consideration a material which was not placed before me.
There was a direction to furnish you this report.
Yes, what has happened?
When? Why, by which order?
My lord will kindly come to page 68. Earlier, my lord, my building was sought to be demolished. I challenged this before this honorable court. There, at
Heard Mr. So-and-so, learned counsel for the petitioner. As directed by this court, the Mr. D. Nath, learned counsel for the learned state, learned senior government advocate, by placing the communication dated 0409-2025, submits that on verification by the verification of relevant records by the respondent authorities, it is found that the report dated 5/09/2023 submitted by the executive engineer building Shivsagar, the basis on which the impugn order has been passed was not furnished to the petitioner earlier. So then,
The contents of the report is important.
uh,
Like, what has happened? The building was gutted.
no, in view of above, the Mr.
Well,
D. Nath, learned senior government advocate, is granted 2 weeks time to bring on record the report by furnishing a copy of, by one affidavit, by furnishing copy to the learned counsel for the
I have given a copy. I'll file the appeal.
list after 3 weeks.
Otherwise, my lord, this report indicates that they engage a private author, the agency, to have a report.
Yes.
Inspection of that.
Yes,
building.
we'll see.
The PWD has said that that particular report is not reliable. That is what we have said. He wants to rely on a report of the private agency, and the PWD has said that that report is not reliable. That is what this is.
my lord, will kindly have a look at page 76.
How
first.
prejudice has been caused to him?
That's why I passed last after
Lots of
3 weeks.
My lord, can you
3 weeks.
my lord, because it's regarding the demolition of the building, my lord. My lord, can it be taken next week, my lord?
Why?
My lord, because there is a notice on interim prayer. I am without any interim prayer, my lord.
But till that, my lord,
Lord, because
nothing has
now
been
in
done,
view
nothing
of
has been
this,
done.
because that
We'll
impugn order
bring
is
it on
based.
record.
No,
We'll bring
Lord,
it on record.
You will not demolish.
Till not now.
Lord, let it be, Lord, recorded that till Lord, this matter
No,
is
petitioner.
Impugn order is what? What
for
does it say?
demolition. For demolition of my building. Lord, notice has been issued in 2024.
This is a commercial building.
Yes. And Lord, I have reports at page 76 for a moment, if your lordship sees.
He has assured no demolition will be
Lord, that
made.
your lordship may record it, my lord.
No, that, my lord, why?
Otherwise,
today-
your lordship
why-
may protect
why-
me, because
why-
without the basis of this, Lord, it has not been Lord, it has not been Lord, broken down for 2 years. In a week or 2 weeks, Lord, nothing is going to happen.
Then
Now,
why he's
Lord,
helping? Then why he's helping today? Let me file the affidavit, my lord. They
Lord,
have said-
no, only thing
The
is,
PWD building has said that it is the report which he wants to rely is not an authentic report. It's not a correct report. Well, that we
Well,
have placed it before your lordship.
direction-
We will file an affidavit to that effect.
Well,
Now,
direction-
why the?
So don't demolish.
Yes, that's it.
Don't give effect to the
Lordship may
impugn
give us-
order.
Lordship may give us 1 week time. Till now, the things are going on. My report has come. I'll file the affidavit, my lord. Otherwise,
Till then, my lord, I should be protected because your lordship sees.
at this stage,
No,
my lord,
in that case,
stage, my lord.
list after 10 days.
Yes, my lord. We'll
But
file
10
the
days
affidavit.
will, my lord
File the affidavit,
may
my
give
lord.
a fixed date, my lord.
Yes, lordship may
10
give a
days.
date.
After 10 days.
Yes, lord.
20.
If it's really unsafe and you are running a commercial,
My lord, I'll show to your lordships how they have violated your lordship's order. There is a direction by
we'll
your
see,
lordship.
we'll see.
My-
That's why I'm fixing after 10 days. All right.
I'll,
But don't demolish.
my lord, file the affidavit, my lord.
We're not recording, we're testing your, the
My lord, but for last 1 year, it has not been done.
19.
not make it 9, after 19.
Let it be 19, my lord.
No,
There's
no.
some urgency.
No, 23
My lord.
or
20,
21, 22 or 21.
21, my lord.
No, 21 is a Sunday.
Make it 22,
23, my lord.
20.
23.
23. Huh?
For that instruction, I'll take back or it will be on.
Yes, you take it back.
Lordship. I'll.
Since you are allowing you to bring on record,
Yes,
you give it
I'll
back.
file it. Otherwise I have given a copy to my lord of plan. I'll bring.
Give it back.
No problem.
I'll.
Known appears for the petitioner on call. Our Mr. N. Goswami, Land State Council, and M. Bhattacharya, N. Bhattacharya, N. Goswami, M. Bhattacharya, Land State Council are present. This after 4 weeks. There's no urgency.
Only 2 weeks time will be maybe granted, my lord, for
On the-
file additional affidavit.
On the prayer of Mr. B. Chetri, Land Council for the petitioner, 2 weeks time is granted for filing additional affidavit.
Lordship, in this series, lordship, may I please your lordship, all these series can be taken up after some time.
Why?
Because standing counsel, Mr. R. Bobudar of Revidio, he is in the midst of one hearing in court number 2.
Which for this item 31 to 38?
I am appearing on item
This-
number 32.
Ah.
Some time may be sought. There is a disputed question of facts.
So, if it is disputed question of facts, we'll dismiss the writ petition.
No, there are some citations by the.
You place it. That was just granted.
Yes,
It was less granted last.
Sometime we are praying for sometimes some direction also
No,
has
no.
to be taken.
Who is appearing? Who is arguing?
Mr. NNB Chaudhary.
Call him.
Kindly.
We'll take after some time.
Lordship.
We'll dispose of the matter.
My lord, I am sorry, my lord. Item number 29, my lord. I could not appear, my lord. My lord,
After 3 weeks.
after 2 weeks, my lord.
4 weeks, I said.
2 weeks, my lord.
Then
My
rec-
learned friend is here, my lord.
Then record his name. 29.
29.
You delete that. Heard Mr. So and so, learn counsel. And they will be same, huh? That will be changed. I heard Mr. So and so, learn counsel for the petitioner. And both of them, huh? N. Goswami and A. Bhattacharya for respondent. As spread for Mr. Mehta after 2 weeks.
Malak, here I have received the instruction, Malak. I may be allowed 2 weeks time to file affidavit.
Who is appearing?
41 month.
The
Which
matter
time may be gone?
may be possible for the time.
Lord, this is my lord admitted bill amount, my lord.
No, she said she has received some instruction. Heard Mr. So and so, learn counsel for the petitioner. On the prayer of Miss MS.
You does.
You does.
The live streaming. I'm here.
Additional
21 or something is going on, no?
additional senior government advocate.
You log into 5.
What is this?
If it reaches, you just say that, we have not received a copy of the. We would like to enter appearance in the matter for the respondent, but we may be served a copy. You say our colleague is there.
What is this? So why they are disturbing? Why they are doing this? From where? Supreme Court? I think it's been adjourned. This has been, I think, adjourned or withdrawn. Anyway,
Yes, my lord, 2 weeks time may be granted.
sorry. Mr. So-and-so, Mr. MS, you thus learned additional senior government advocate, additional senior government submits that she has received the instruction and therefore 2 weeks time may be granted to bring on record the instruction. Mr. Procedural, list the matter after 2 weeks.
So the date may be fixed, my lord.
Why?
Otherwise, my lord.
Let them file.
My lord,
2 weeks. 2 weeks. 2 weeks means virtually after vacation. Yes, next.
42 is
Yeah,
similar.
my lord.
Identical method.
Wait for time, my lord. I have received instruction, my lord. So, after.
You have not received.
But in this case, I have not received, my lord.
Will not say in that case further 2 weeks time is granted on the prayer of MS.
You does.
You thus learned addition senior government advocate. Further 2 weeks time is granted to file affidavit.
Oblige.
Obliging.
I have received instruction.
Yes.
Revised estimate has been prepared and sent to PWD. So, if the logic directs me that I can file an affidavit.
There is admitted. Matter is admitted.
Not, that has been.
So this is the land valuation in terms of, you file an affidavit. Have you filed it? No. Will allow, heard Mr. So-and-so, land counsel, but Mr. Vijay Talukdar, land addition senior government advocate is granted further 2 weeks time to file affidavit in opposition. Yes.
44. Oblige.
In this case also instructions for formal.
Lordship, we are yet to receive exception.
Further 3, same heard Mr. So-and-so on consultation. Further 3 weeks time is granted for filing affidavit to Mr. Vijay Talukdar, learned additional senior government advocate.
Right. 45 go to exception.
Same.
No, I have received exception. I would like to.
You want to file affidavit? No. Heard Mr. So-and-so, learned counsel for the police. It's a non-COVID death.
Lordship, government has already, Lordship, given award, Lordship, to the persons who died due to COVID-19.
But it's on.
I'm sorry, my dear, I'm not in this case.
Huh?
I'm not. It was.
As for this, after verification, it was found that it was not a. It was a non-COVID death.
Come to the page number 21, Lordship.
Mr. So-and-so, who is appearing?
Postmortem report was there, Lordship.
Who is appearing? Not Mr. So-and-so, learned counsel for the petitioner. On the prayer of Mr. A. Bhattacharya, learned state counsel. Further 3 weeks time is granted to obtain instruction and file affidavit in opposition.
The date may be fixed, Lordship.
3 weeks.
46.
To be fixed by the registry. Registry will fix it.
Okay.
46.
Yes, it's already demolished.
Lordship, I pray for response 789, my lord.
Yes. 7, 8, and 9 is R who? 7, 8, and 9?
Private respondent, my lord.
You are private respondent.
Yes, sure.
How you can demolish?
Lordship, no, I pray for 2 weeks time, my lord.
No one appears for the petition on call. Mr.
DZMD.
DZMD. Who is for the state? SS Roy.
Lordship.
For respondent, London State Council for respondent, state respondents, and Mr. DZMD, Land Council for respondent numbers 7, 8, and 9. What is your authority to demolish others' property?
We have no authority.
On the prayer, Land Council for the respondents, further 3 weeks' time is granted to file affidavit in opposition.
47.
On the last day, Lordship, instruction was 45 days.
Yes.
Lordship, that order has already been communicated to the concerned officer, Lordship,
Hmm.
but that instruction is awaited.
Heard Mr.
M. Khan.
M. Khan, Land Council for the petitioner. On the prayer, Mr. P. Naik, Standing Council, BTC, further 3 weeks' time is granted to obtain instruction. Yes.
My lord, in this case, we applied for land sale permission, Lordship. Land sale permission, Lordship.
Land sale.
Lordship.
Yes.
26 is the acknowledgement receipt, Lordship.
Who is appearing?
We are waiting instruction, Lordship, not repeat, Lordship. Some
Uh,
may be given, Lordship.
Heard Mr. So-and-so, Land Council for the, on the prayer, Mr. S. Roy, Land Council, State Council, further 2 weeks' time is granted to obtain instruction. We'll see. While granting you 2 weeks, you just obtain the instruction. What's wrong? Why his case has not been considered?
Lordship.
That's all. Ah.
59.
Yes.
In this case, my lord, the contractor with the two walls, he completed the entire walls within 40 days. The time as was allocated in the work order.
Yes. But
Therefore, he is asking for money, but the authority has not paid the money.
why they are not paying you?
I do not know why they do not pay, but I am trying. They are trying to take funds from the different authorities, but
Yes.
money is not there. In the event the petition of the mothers here is also a cancer patient, madam.
Yes. Who is appearing? Who is appearing? Who appears for the respondent, sir? State of Assam, Special Commissioner Secretary, PWD, Joint Secretary, General Administration, Commissioner and Secretary, Finance. Nobody is appearing. Today is second day.
Yes, but second was I need money.
Yes, definitely.
Mother of the patient is campus initial money for taking care.
3,75,000.
Chemotherapy.
3,75,000.
No,
Your claim is 3,75,000.
no, Lord. 3,83,053 and 3,73,000, 75,489. It is for both of you all orders. In my 19 and
Both
20.
work orders.
Page 19, madam.
Yes.
Page 19.
70. 7 lakhs and odd.
Yes, ma'am.
Yes. Who is appearing? PWD, finance. Heard Mr.
PC Raimit.
Learned counsel for the petitioner. Not appears for the state of Assam. No, it's for the responding authorities, the state of Assam. For the 3 weeks time is granted to obtain instruction as to the admission.
It will be too late, my lord. Already my money is very urgently.
1 week in that case to obtain instruction. You inform all of them.
1 week, my lord, that date may kindly be fixed there. 1 week.
After 1 week.
After they will not put the extend after 1 week. Date fix here after
Okay.
1 week.
You give the date after 1 week. Not 18. After that. After 19. Yes.
24.
Dear Lordship, I pray for some time, Lordship, instruction not received, Lord.
My senior will allow for video conferencing.
My lord, I beg to appear, and my lord, I must at the outset apologize, my lord, because my mic had suddenly accidentally turned on, my lord. I'm deeply sorry, my lord, for that.
Yes.
Lordship, here I pray for some time for not receive the instruction.
What is the matter?
Well, the matter pertains to, my lord, there was an auction sale of Tea Garden, my lord, way back in 2004. And, my lord, the auction sale was eventually set aside by the my lord.
Mr. They want some time to
No difficulty.
obtain this. Heard Mr.
A. Phukan, my lord.
A. Phukan, learned counsel by the petition. On the prayer of Mr. S. Roy, learned state counsel, further 3 weeks time is granted to obtain instruction as to whether the claim of the petitioner is admitted or not, is an admitted amount or not. Huh?
My lord, may I just request, subject to your lordship's convenience, a specific date, my lord, so that I could be there physically, my lord?
After 3 weeks.
May I request for 24th of October, if that is convenient, my lord? 24th October.
Where are you?
I'm in Delhi, my lord.
24.
I'm deeply obliged, my lord. Deeply obliged.
In this case, this honorable court directed me to file an affidavit. The court for delay in filing the affidavit. We filed affidavit. Thereafter, lordship court directed us to inform when they have received a copy of the writ petition. Lordship have received.
So what is to be done today?
Lordship allow some time to file affidavit.
Heard MS learned counsel for the petitioner. On the prayer of Mr. S.C.K. learned counsel, learned standing counsel GST. Further 3 weeks time is granted to file affidavit in opposition.
For respondent number 1.
So are you filing affidavit? No.
Here's the formal part of it. 1968.
On the day before yesterday, we have got a affidavit in opposition by respondent number.
On the prayer of so-and-so, learned counsel for the petition time is granted to file affidavit in reply.
No, we have received the affidavit in opposition on day before yesterday. So matter will be fixed on Monday, my lord.
Why?
So I have prepared for respondent 2 and 3. You are filing today, my lord.
So matter will come up
After
Monday.
10 days.
A date will be fixed.
So-and-so, learned counsel for the petitioner, who submits that he has received the affidavit in opposition file on behalf of
Respondent number 4.
respondent number 4, day for yesterday. Next
2
paragraph.
and 3 today we are filing.
Mr.
B. Chakraborty.
B. Chakraborty, learned counsel for respondent number
2 and 3.
2 and 3. Submits that he would be filing the affidavit in opposition during the course of the day.
Awesome.
in view that this matter be listed after 2 weeks. 2 weeks.
Both of them.
6970. Yes, record her name. Let's give this 69 and 70. Continue. Continue 69, 70 orders. You just give this. No, it was, you just give this 69 and 70. We'll complete this. Orders today is nothing to be done. Did you know? Just 69.
No. Item 69.
Yes.
Now, appearing for the petitioner, on the last date, the counsel for the bank, the State Bank of India, had sought time to take instructions. Steps are completed, notices have been served. The issue in this case is my bank account has been freezed by the respondent bank from 2000.
This is for orders. Why this is listed for? Have you filed? Have you taken Dusty? You have taken the.
Your Honor, steps are complete. All are on the last date they have appeared.
Respondent 1 to 5.
Yes. Today was the date for reply from the bank authorities. They were supposed to take.
Where is the bank? Heard Mr. So-and-so learn counsel for the petition. None appears for the respondents. Mr.
Your date may be fixed after.
This the matter after 2 weeks.
Okay.
Item 70.
DC Ramre. Yes.
We have received instructions like to file affidavit. I'm for respondent number 1, 6, and 7.
None appears for the petitioner on call. Office note dated 09/09/2025 indicates that ID card in respect of ID card, neither the ID card nor the answer notice in respect of respondent number 8, 9, and 10 have been received. List of Mr. So-and-so learned counsel for the petition. Respondent number?
1, 6, and 7.
Respondent, state respondents.
NHA and NHA-DCL.
Respondents. NHA-DCL. NHAI and NHAI-DCL. Respondents granted 2 weeks time to file affidavit. Then record his name.
Yes, that's my lord.
3, 4, 5, and
You delete that thing. Are you filing affidavit?
3, 4, and 5.
S. Roy. Then in that case, S. Roy and this NHA and so and so.
Hello.
We'll finish the order first. We'll take it a go. Yes.
Lordship. Step complete.
What steps?
We have taken steps. They have appeared respondent. Lordship, they took short time for.
When?
For last occasion also.
What last when? Are you sure you are Mr. Bora?
I'm Mr. S there.
Huh? none appears on behalf of the petitioner. You have not appeared before the Lazima court also. No steps that it will practice for the police. You have not taken fresh steps for response number 5. Even after obtaining the stay order, interim order.
Lordship will take.
So why you are saying? Had Mr. So-and-so learned counsel for the petitioner. List of office note dated 2008-2025 indicates that despite repeated direction, no steps have been taken by the petitioner for service of notice upon response number 5. List of. On the prayer of the Mr. So-and-so learned counsel, a last chance is provided to take fresh steps for service of notice upon response number 5. In case of default, no, please, in the event of default, the interim order was earlier then vacated. If you fail this third time, you have failed.
Lordship will take a step.
Then otherwise it will automatically be vacated.
Oblige.
Yes.
My lord, this is a similar case we had as in the earlier case, that despite my lord 2 opportunities, they have failed to take steps, my lord, on the respondent number 5.
On that ground, Lordship, we have taken steps. There has been some misunderstanding on the part of the registry of this honorable court, Lordship. Some orders have been, some orders passing some other writ petition, Lordship. They have been placed in this writ petition, Lordship. Lordship, I have the postal Talabana, Lordship. In terms of joint registers order dated 22/3/2024, we had taken fresh steps, Lordship, on 14/5/2024.
No, we'll say in that case, we'll say heard Mr. So-and-so learned counsel. No, although office note dated 04/09/2025 indicates that the petitioner has failed to take any steps for service of notice for issuance of notice upon the response number 5. However, Mr. So-and-so learned counsel for the petitioner submits that he has already taken the steps for service of notice upon response number 5. Has already taken steps for the service of notice. On when?
Lordship, 14/5/2024, we have taken, we have filed the postal Talabana, Lordship.
14/5/2020. And the order appears to have, the office note appears to have been recorded in view of the communication gap. Appears to be in view of.
Well, in view of his statement, in view of his statement that he had taken steps, let the office verify.
No, that's what I'm saying.
Yes, ma'am.
That's it. You said. What is the last? Last you delete, huh? No, you just delete that. Huh? Next paragraph. In view of the submission of learning counsel for the petition that the steps for which what you have filed? What you have filed?
Lordship, we have challenged in the writ petition, Lordship.
No, steps. For steps, what documents you have filed to show that you have taken steps?
Lordship, the postal Talabana itself is there.
Where it is?
On 14/5/2024.
Where?
Lordship, that is in the.
In view of the the registry to verify and list the matter after 3 weeks.
Lordship, there is an interim order.
Interim order passed and let's continue. Mr. You are for? And?
420.
ठीक. none appears for the petitioner on call, nor any steps have been taken by the petitioner for service of notice upon respondent number 5. It is noticed that on the last listing, petitioner was also not represented. No. Petition the non petitioner was also not represented. Huh? List the matter after 3 weeks. It is clear that on the next day, if the petitioner is not represented, appropriate orders shall be passed. This court will consider passing appropriate orders.
56. This case, the amount was supposed to deposit within a period of 1 week, my lord, as per the version of my allotted friend.
My lord, may I submit, my lord, about the latest?
The last order, lordship will issue.
Yes.
My lord, we have got the sanction, my lord. The money is with us. It is about 1.35 crore that will have to be paid to the petitioner as a land compensation, my lord. Now, my lord, we prepared it, my lord, to be deposited to the office of the joint director, and he will thereafter furnish it to the petitioner. Now, my lord, deputy commissioner says that since it is a land issue, it will have to be deposited in the office of the deputy commissioner's head of account. So we are preparing for that. It will be paid, my lord. Sanction has been issued. 1.35 crore, it is there. It will be paid. Because of that particular, my lord, discrepancy, it has got delayed. That will be after the Puja vacation, my lord. In fact, today also they are, my lord,
For a week, my lord. Otherwise, my lord, this matter is pending for long time, my lord.
We'll close it. It's compliance.
No.
Yeah, maybe a little.
Compliant, my lord.
No, my lord, let them deposit the amount, then lordship will close the matter. After a week, my lord, lordship will fix the matter. Otherwise, my lord, matter of the judgment
And
was
Mr. B. Chetri, land counsel for the petitioner.
On 15th of October, my lord.
this prior to this, my lord, this September, my lord. September, lordship.
Yes, enjoy them. We'll fix the matter on the last day,
26.
26, so that they can enjoy the
Exactly, my lord.
puja
Yes.
with this money.
Yes, my lord. No, my lord, this petitioner
As
is lying in the bed, my lord.
As agreed to by the land counsel for the petitioner. Let this matter be listed on, let this contempt petition be listed on 26/09/27. In the meantime, as submitted by Mr. As Mr. B. Gover, then counsel for the Alice contempt. The process for payment of the compensation shall be completed.
No, I'm not saying it will be completed by 26. I'm saying that, my lord, we are working on it, my lord, so that we can deposit.
Now, why is this depositing it that hardly one day?
Yes. I can't say these are, my lord, procedural works, my lord. It will have to be deposited in a
And
particular
submission
head
of land counsel for the process for payment of the compensation is under process.
Try to, my lord, yes.
It
Try
is
to
expected
complete
that the petitioner the respondent shall complete the process on or before the next date.
Yeah. Lordship will say, my lord, only I will try, my lord, that.
No, you do it.
My lord, I appear for respondent number 3.
Obliged to lordship.
57.
Award service report. On Mr. M. Sharma, land counsel for award service report, list after 4 weeks.
My lord, if you be directed to take fresh steps, my lord.
It's up to you.
Yes, my lord. Okay.
And in that case, as spread for Mr. M. Sharma, land counsel for the petitioner, is permitted to take fresh steps.
Grateful, man.
58.
Yes, last occasion you did not appear.
Yes, ma'am.
Why?
Actually, I was out of session. My senior is not well. Even we have taken the steps today only. We have received a
It is submitted that,
Yes.
when it's submitted by Mr. So-and-so.
R.A. Law.
Huh?
R.A. Law Court.
Learned counsel for the petitioner. That he has taken steps to the Mr. S. N. Goswami, learned counsel is present. Accordingly, this matter after 4 weeks.
Upload.
59.
Please, Your Lordship.
Yes.
Lordship, in respect of the respondent number 10, we have taken steps through postal Talavana as well as through Dusty, and I filed an affidavit also, Lordship,
Where it
regarding
is?
Dusty service.
You have filed.
Yes, Lord.
Lordship, I am for respondent number 1, 1, 2, 3. 4.
Anybody appeared?
Oh, Lord, 9.
No name.
Respond number 10.
Lordship.
Mr. Mr.
Yes, they Lord.
One Mr. S. Day,
Lord.
learned counsel for the petitioner. And Mr.
Shi Sharma, Lord.
C. Sharma, learned listed counsel for respondent. Next parent. Petitioner has filed an affidavit regarding the proof of service of notice upon respondent number 10 by Dusty Mount. Mr. The result of the notice dated 25/02/2025 indicates that the respondent number 10 has received the notice, received and accepted the notice. Accordingly, the service notice of service on respondent 10 is complete. We are filing affidavit. Since the respondents are granted 3 weeks time to file affidavit. Just after 3 weeks.
Much of Lord.
Item 60.
No appears for the petitioner on call. Office note dated 22/08/25 indicates that no steps has been taken by the petitioner. List the matter after 4 weeks. In the meantime, petitioners to take steps.
I'm appealing for 4, 5, 7 to 15.
SS Roy. State Council.
No, Lordship, Standing Council, Tinsukia Municipal.
Huh?
Standing Council, Tinsukia Municipal Board.
Okay. This is MC.
You are.
No one appears for the petitioner on call. List after 2 weeks.
62.
This is Miss cases for restoration of the repetition, my lord. It
Yes.
was dismissed for default on 9/6/2025, page 18. Page 18 is the order, my lord. And the reason I have stated in paragraph number 6 that I was in court number 3. I was in court number 3 for a review petition where I was arguing for quite long time, my lord. Honorable, that's why, my lord, I could not appear. And this is for non-prosecution. My lord, I pray for restoration with this petition.
Any private respondent? No.
They are for the respondent, my lord.
Private respondents are there.
private, no, my lord, they are all government.
Huh?
All government, my lord.
Government,
Yes, all government.
district commissioner, circle. Yes, what do you say? Any objection? Any objection?
No,
Huh?
no objection, Your Lordship.
Okay.
In most of the occasion, whenever matter comes, he doesn't appear, Your Lordship. In read petition also, Your Lord.
We'll impose
My lord, sometimes
10,000. What is the matter?
but regarding, my lord, payment of compensation for land and Gerard, they have not paid. They have said, my lord, they have paid, but I have annexed some
Aren't
documents.
Mr. So-and-so
Argusami.
learned counsel for the
Argusami.
miscellaneous application? Learned counsel for the petition, huh? And so-and-so, who else?
K. Pukan for respondent number 1 to 4.
1 to 4 and
for 6.
then all represented. Next period.
Your Lordship, I
Yes.
1 to 5, Your Lordship. 1, 2, 3, 4, and 5.
Yes. By filing in this miscellaneous application, the petitioner has sought for, has prayed for a direction, prayed for restoration of the writ petition being WPC number 608, which was dismissed for non-prosecution by an order dated 09/06/2025. Where is your ground?
Para 6, my lord. Page 12, para 6.
You are Goswami.
Yes, my lord.
Having considered the submissions of Land Council for the petition and also the grounds for the restoration to the effect that the Learned Council was in the midst of argument before other court when the writ petitioners called on 9/10, what is that? 9/06/2025, and the prayer for restoration of the writ petition is not objected to by Learned Council for the respondents. I deem it appropriate to allow this writ petition. Allow this miscellaneous application, Mr. According the writ petition being the WPC 608/2025 be restored to file. Mr. The order dated 09/06/2025 is recorded. Can I take it up? Will
Yes,
it not be before the appropriate bench? As the bench who has passed the order? Restoration, no issue.
No issue, my lord.
No bar.
Yes.
Business application. No. Restored to file. Subject to the payment of ₹5,000 to be deposited by the petitioner to the before the what is called?
They are very poor petitioner, my lord.
Bar Association. The welfare fund of the Bar Association.
They are very poor
Bharatiya
party, my lord. They have not received their compensation. How they can?
2,000. Then 2,000.
1,000, my lord.
2,000.
From my pocket, I will pay.
2,000.
Obliged, my lord.
Shall be deposited.
Guwahati High Court Bar Association.
Guwahati High Court Bar Association.
Oblige, Your Lord.
Obliged, my lord.
Item 64.
What is this IA?
My lord, the IA basically is arising out of a, my lord, impure notice of demolition, my lord. At page 41. What has happened, my lord, during the pendency of the main writ petition, my lord, they have issued this notice. My lord, in the main writ petition, my lord, our basic grievance is that, my lord, notices after notices have been issued. And, my lord, we have responded to all such notices, my lord, regarding our residential house. But, my lord, and of late, this notice at page 41 have been issued, my lord, of the IM. They are saying that, my lord, we should, under the whatever the, my lord, requirement is required for construction of a dwelling house, that has not been followed. And, my lord, therefore, we have violated, and basing on a, my lord, third-party complaint, my lord, this process has been initiated, my lord. My lord, what has happened, my lord? We have a very, my lord,
It's a long time back.
Long time back, my lord. What has
29/11/2024.
My lord.
What happened? Who is for the corporation?
My lord, I am for respondent number 4, my lord. My lord, I have no copy of the reputation and my lord interlocutory application, my lord.
You are respondent number?
4, my lord.
Who is respondent number 4?
I am respondent number 4, my lord.
Who is respondent number 4?
My lord, she is the private respondent and she has lodged the complaint against.
You furnished.
Hazarika,
You furnished.
Lord, we have already taken steps. My lord,
Mr. You furnish what's there since he is a friend.
No, my lord, I am going to furnish. What is the problem? My lord, the urgency is that, my lord, we are apprehending that the people of the GMC authority may come and demolish our residential house.
Yes, you furnish the copy first. List after 10 days.
Can it be after, my lord, next
Mr.
Tuesday?
A.R. Boya, Learned Counsel. Heard Mr. A.R. Boya, Learned Counsel for that. The Learned Counsel for the petitioner furnished a copy of the writ petition
Along with the
as well as introducing the application to Mr.
M. Hussain, my lord.
M. Hussain, Learned Counsel for the respondent for. Yes, what is the status? You have been directed to pull down, demolish. Way back in November 2024.
Lordship, notice was issued. They are not replying, Lordship. No, submit the reply. We have submitted reply. If you want to help, that is on record, my lord. Those replies are on record, my lord. No. My learned friend.
If they don't reply, you pull down, demolish it. What's there?
Only because, Lordship, the person concerned is also an advocate, Lordship.
That is the
only consideration from my side. No, my lord, that should not be the.
Yourself.
No, my lord. My petitioner is a very active member of this bar, my lord. She is not here today.
So why you are indulging in illegal activities?
She has filed the reply, my lord. She being an advocate, my lord. She has
Very
filed the
active
reply.
member of the bar should not indulge in the activities. What it will send a very wrong signal.
Lord, this is
Negative signal to the society.
Lord, this is a temporary one.
Okay, list after 10 days. We'll consider.
My lord. Obliged, Lord. Lord, till then they may not do anything, my lord. That observation.
Since you have not done anything till today, don't do. We are not passing order. We'll consider on that.
We are not doing anything, Lord.
Yes, we are not passing it.
Lordship is not passing any order.
Yes.
We are not doing. My lord. This case is pending since 2022, Lordship. We are doing nothing.
Yes.
Only because of that consideration. Obliged.
But next time we are not considering. Will not consider.
My lord. Obliged.
65.
The I4 substitution of the petitioner also.
Yes.
See, the death certificate is at page number 7.
It's okay. This is an heard Mr. So-and-so.
US border.
US
border. Uday.
Okay. United States border.
Yes, sir.
US border, London Council for the applicant. Writ petitioner. An applicant.
Applicant.
And Mr. Both of you.
2, 3, and 4.
So no, both, 4 respondents, Record them.
I pay for 1.
3. 2 of them. 2 of you. 2 of you are applying. Yes, then record their name for all the respondents. This is an application seeking substitution of the name of the petitioner, who has reportedly expired.
Expired, Lordship.
Expired.
Page number 7.
On?
Expired on Lordship, 2/3/2025.
2/3/2025. List of having considered that the petitioner has expired during the proceedings during dependency of the, in the connected WPC member. Substitution of the petitioner, the connected with petition. No, not connected. Petitioner in WPC number 5965 of 2024 by her legal heir.
Legal heir also is solved.
Having considered the submissions will consent for the parties and the prayers not being objected to the let me consent for the respondents for substitution, and also considering that the petitioner has expired during dependency of the writ petition, during the dependency of the writ petition. I deem it appropriate to allow this application by allowing the legal heir of the petitioner to be substituted to be substituted by legal heir. What is the name of the
Bhupesh Pathak, Lordship. Bhupesh Pathak.
There is one more son is there also, Lordship.
Accordingly? Where is the name?
Not there, Lordship.
Lordship,
Applicant is there only.
applicant, paragraph number 3.
Okay.
The name of the petitioner may be, that is the applicant.
Accordingly, the applicant, being a legal heir, be allowed to be substituted as petitioner in the writ petition so and so.
Lordship, there are,
I stands allowed on this.
there are two sons, Lordship. In the legal heir, page 9, Lordship.
Ah.
Legal heir, both of the legal heirs should come, Lordship. Only one name is there, Lordship.
Yes.
Lordship, at paragraph number 3, I have written it in the Lordship. The applicant is duly authorized by his elder brother to act on his behalf.
Yes.
Lordship.
Allowed in this person.
Obliged, Lordship.
What about 66? 66. 66. Adjourn. Okay.
11 and 12, Lordship. May I please, your Lordship?
What is this?
Lordships, I purchased a plot of land. It was registered, so that is not disputed. Accordingly, I applied for construction of boundary wall. Authority allowed me to construct the wall, that is page 24.
But it's the government
Government
class
lordship,
land. Then
thereafter I also applied for construction.
no, you are having a you
Suddenly
sir, you are having a this thing patta land. You may
Patta-
construct, but
patta land.
they are evicting you.
They're stating that
They have evicted you from the government caste land.
no.
How
I am
it's a
residing-
dispute? This is the dispute.
No, Lordship, this is I am residing and constructed house, shop.
Maybe
everything
within your
patta land.
patta land, but you must have encroached it.
No. There is a boundary wall also. Everything is there, Lordship. Their statement is.
What is the
Lordship, kindly see.
impugn order?
Lordship, kindly see.
Impugn order,
Notice-
please. Notice. Where is the impugn order?
Lordship, kindly see notice 34.
Page?
Page 34, notice.
Lordship, kindly take item number 12 first, Lordship, because this is old one.
It is hereby informed you that due to illegal occupation land by constructing shops on the roadside of PW and National Highway, etc., there is a great deal running the vehicles and that may cause accident. All the shopkeepers are asked to remove the shops and of their own responsibility. Otherwise, the shops will be demolished. It has been demolished.
Yes, they demolished 5 numbers of shops and also
Okay,
demolished
genuinely,
my
they have rightly done it.
No, Lordship, they can't. They, in the meantime, their Lordship.
Yes, in the
land
next page, where is this?
Lordship, kindly see.
Where is the impugn order in the other case?
In Lordship, kindly see, impugn order is that, Lordship, prior to that, Lordship, kindly see that representation I submitted page 37.
Which one? Which method?
Let WBC number 14212 or 20. That will clear in both the case. After getting interim, they have cancelled my NOC for construction of RCC building.
She is referring to the second case, 72794.
To the 14 lordship, it will clear all the first one also. Because after getting interim order.
Civil court lordship disputing.
Why did disputing?
We are saying that it is government land, our affidavit saying.
You admitted my land.
No.
It is my land. Affidavit is there. Your other affidavit is kindly see admitted L by only one respondent denied. Other respondents lordship, the respondents number 3 affidavit filed in the first one case, they admitted all the statements. Respondent number 2, 3, and 7.
Where is it?
Yes, kindly see.
5 and 9, kindly see.
Because statements made in paragraph 1, 2, 3, 4, 5, and 8, the petition answer deponent does not want to make any comment. In respect of paragraph 9, 10, and 11, but others all are admitted. They admitted 5 numbers of demolition. They admitted my wall, boundary wall. They admitted there is a demarcation took place. At one respondent contradictory statement making
Demarcation took place. You have encroached the government cast land.
no.
Not your.
I also admit any part of my shops fall under government land that may be demolished. Even by representation, I annex.
That is accordingly they have done. What's there?
After issuing notice, lordship, I submitted notice issued to the husband of the petitioner. Husband stated that owner is the wife, even that he submitted represented. That's why lordship pays 37. Of second case lordship 1412 up to the 20. May I read? That is very important. I also admit if any part of falls under the falls under government house land, that may be demolished.
Yes.
May I read, lordship?
Why this two petition?
Because after getting interim order, they cancelled my NOC for construction of RCC building. They issued a NOC for construction of RCC building.
That was wrongly issued. That was wrongly issued, therefore it was rightly cancelled.
Wrong issue, but since they demolished my 5 number shops and wall.
Because you have encroached the government land.
No.
It's a government cast land. So who will decide?
Assuming, but not admitting.
Who will decide? This court will decide.
No.
Then
the question is that they can't cancel my NOC. They issued NOC for construction of wall. They issued NOC.
Right to issue
they issued,
includes the right to cancel. I mean the power to issue.
No, on what basis, lordship?
Includes power to cancel.
If any part of the building or boundary land falls beyond my land, they have all right to cancel, lordship. They have all right, I admit.
We'll take it up at 2 o'clock.
They can't.
You kindly prepare your case properly. We'll hear you and dispose of.
Lordship.
Not here and there. Not pointing, not here and there. Don't jump here to there.
So,
Please prepare your case. We'll take it over at 2 o'clock. We'll dispose of the matter.
Even if lordship taken up the second case, it will also clear. They filed affidavit in the first case.
Your case will be taken up. We'll resume at 2 o'clock.
May I please the lordships?
Yes.
Some more time required for preparation, lordships.
Why?
After a week, lordships, sir. 2 cases. Some more time, senior is also required, lordships. My senior is also required in this case.
Why?
After a week, lordships. Some more time may be given, lordship.
No, we're disposing today.
Lordships, lordship knows that I am fully not prepared, and in the meantime, break time not completed for preparation. After a week, lordships. After a week.
What is there? Nothing, there is nothing now.
My satisfaction, lordship.
Will not say.
Satisfied, lordship. I will satisfaction is required, lordship.
What your
Just a
satisfaction?
Preparation is required, some more.
They said you have encroached and you have used
No.
constructed
Their
a
statement
stop.
wrong, lordship, but within the boundary, lordship, that shops are constructed. This is
You have illegally constructed the shops. You have illegally constructed some part of the boundary wall.
Their shops, no.
It's beyond your patta land.
No. Within the boundary, lordship, everything's up there. They issued NOC for construction boundary. They issued NOC for construction.
That
of
has been
building.
cancelled.
They have, because of approach dishonorable code, they have cancelled. That in the notice reflect lawsuit. That's why some preparation is required in this, some research also required lawsuit. After a week lawsuit take up. And then in the notice also mentioned, because I filed a case.
Friday. No, Thursday. Next Thursday.
Next Thursday.
Today
is the Wednesday.
18.
18. Lawsuits.
Although I heard Mr. So-and-so learned counsel for it. Although the matter has been, matter is heard, although, no, the matters have been heard at length. However, after arguing the matter for some time, Mr. Wood, what? F.U. Burbuya, learned counsel by the petitioner, submits a praise for listing of the matter on 18/09/2025, so as to enable him to prepare to further prepare the matter and to address this court. List MS Army Bora, learned counsel for the petition. A respondent is present. Accordingly, on the prayer of Mr. Burbuya, learned counsel for petition, let this matter be listed on 18. 18.
Obliged. Interim order is there, that may be continued.
Interim order possible.
Thank you. Item number 12.
Keep your.
Please, my lord. Here in the instant case, my lord, without serving any notice, my lord, under Rule 18(2), my lord, there is a division by judgment of this honorable court, my lord, Salakuddin. You have to issue notice and thereafter you hear the matter. OD and partem should be fulfilled. That was not done. State they tried to evict the petitioner, but they could not evict, my lord, partially damage the house. Last point, when I argued before this member, my lord,
no, petitioners have already been evicted.
Yes, my lord, I am coming, my lord. They have said that we have evicted from my place, from my lord, residence, my lord. And we submit we are not evicted, my lord. That is, my lord, that is the corroborative affidavit also. He is also there, other is not evicted. We have take some photograph also, my lord. I shall, now the question is, my lord, disputed question of fact, my lord. The learned friend has said it is a disputed question of facts, my lord. So it is not applicable. My humble submission before your lordship is that, my lord, in this case, my lord, what happened? It is a matter of eviction, my lord, from the petitioner place of business, place of my lord, residence, my lord, dwelling house, my lord. So my humble submission as per decision of the apex court, my lord, this is not disputed question of, first it is a, I am denied that it is a disputed question of fact. Second, even it is assuming but not admitting, it is a disputed question of facts, then also petition lie, my lord. I am stating coming to this judgment, my lord.
No, what is your matter? What is your case?
My case, my lord. Petition, my lord. My petition is that, my lord, we are in the government land, my lord, for last 30, 40 years, my lord. And we have submitted the Kobula, my lord. There is a settlement rule, my lord. If a person stay, my lord, more than, my lord, 20 years, then he can get the settlement on the particular land, my lord, provided land is 15 years, no? Provided the land is suitable for settlement. Here in the instant case, what happened, my lord? They say, DAG number 97, my lord, they have, my lord, this land has been allotted to be one, my lord. There is a hospital to be, my lord, that's, my lord, from my plot of land, that's about, my lord, half a kilometer TB hospital is there, my lord. They have said that land is TB hospital. Then, my lord, minutes of the meeting has said that this land was not given. DAG number 98 was given. Our DAG number 97. Most important thing is that, my lord, in that DAG number 97, one person has been settled, my lord, Bankim Chandra Biswas and Madan Chandra Biswas, my lord. When who is adjacent to the petitioner number 3 land, my lord. And, my lord, other here and there, my lord. And when they settled, my lord, they said this land is the government land which has been suitable for settlement, and settlement was given to the Madan Biswas and Bankim Chandra Biswas. There are another person, my lord, Arun Kumar Singh. When their settlement has been given, they categorically said that number 97 is not belongs to the TB hospital, my lord. That is the position of the case, my lord. Last time, before going to that, my lord, last time they have, my lord, hesitated one question by them. The house has been already been demolished. Although house has not demolished, my lord. To that disputed question, your lordship, there is the last order, my lord. Passed by the Honorable Justice Bedi. Otherwise, my lord, this notice go. Similar matter, my lord, this honorable process, circular officer cannot issue notice, my lord, notice of eviction order. This was passed by this honorable court, my lord. Let's kindly go through this, my lord. Similar type of matter, my lord, in next paper, DAG number 96.
Who is the authority to issue notice?
Deputy Commissioner is the authority of the
Under which law?
Yes, my lord.
Under which law?
Lordship, directly come to the judgment, my lord. Everything has been discussed, my lord. May I read, my lord? Hard Shri so and so learned NNB learned council of petitioner, SR learned state council, R state council. The grievance of the petitioner are 7 number in against the individual notice 37/2000 issued by the circle officer Guwahati Revenue Service directly vacate their possession. The Chaudhary Learned Council submitted that a similar issue was earlier raised by backs of petition which was disposed of with direction of the Honorable Court judgment dated 7 of the in which a certain direction was issued. It is submitted that in violation of the aforesaid direction, imprint notice has been issued. There is also emphasis the land in question is not part of land reserved for the TB hospital, and the petitioner are in possession of the land since a long period of time. We also submitted that petitioner number is a higher petition long period of time, and there are relevant in consideration. Chaudhary Learned Council of the informed the additional affidavit has been filed today to bring the record of clarification of the petition. As regarded the impugn notification notices, it has been submitted the circle officer Guwahati Revenue Circle would not be competent authority to issue the same in view of the clear direction of the court judgment order 7/11/2012. 7/12/2024 has said it is the deputy commissioner who said issued the notice. I shall go to the judgment matter later on, my lord. The purportedly learned standing also revenue department while disputing the some other matter on the behalf of the regarding the claim that land is not reserved for TB has clearly considered that notice by the circle officer do not appear to strict compliance of the direction of this honorable. He however hastened to add that there is no prejudice caused to the petitioner as the successfully gone to the giving fair hearing was done. To appreciate the rivalry, it would be necessary to look direction. This court order dated 7/11/2024. The impugn notice rule 18 so as to petitioner to vacate shall be a notice issued by the circle officer Guwahati Revenue Circle to show why the petitioner should not be evicted by taking recourse to rule 18 settlement. The petitioner present that some is given liberty to submit individual reply substantiating the same with document and such evidence.
No, no, in this case, there was a direction by the court.
Yes, so last direction.
Earlier, the deputy commissioner shall
Yes.
was directed.
Yes.
Therefore,
And now.
circle officer has issued a notice.
Notice, my lord. So, my case is.
That is the ground. Therefore, since the direction was deputy commissioner.
7. It appeared the order to send the deputy commissioner cannot give an opportunity of hearing it. They however not issued by the deputy but the circle officer Guwahati. This court is therefore opinion that without making any comment, internship merit of the rival party on the ground that notice have been issued by the authority which is not mentioned as per direction of the court.
Yes.
7. Here also notice has been issued by the circle officer.
No, is there any direction?
My lord?
Where is there any direction in this matter that it should be a deputy commissioner?
My lord. Eviction notice has been issued by the circle officer. Your lordship kindly come to directly, my lord.
Sir, what I am asking is, this is a case. What about this order passed by earlier in this?
In the similar matter, my lord, there is a series item number, DAG number 96. The notice has been issued by the circle officer. The court has already, my lord, decided that circle officer cannot issue the eviction notice. So that notice has been set aside. Here, your lordship, kindly page 96 of my petition. So, my lord, that circle officer notice has been passed without jurisdiction. That is why set aside, without going to the merit of this case.
That's why. What is the law that circle officer has no authority? Who is the authority to issue notice?
Deputy commissioner is the.
Where?
authority.
Which law?
Settlement.
This order was passed based on the earlier order.
Yes, sir.
This called
So
07/11/2000.
That will be important, my lord. Earlier order, my lord, your lordship kindly come.
No, you just show us the law under which the notice has to be issued. Which authority has to issue a notice?
No, okay. Rule 18(1), my lord. Yes, sir. Like that, man. Rule 18(1), have a look at it. Subject as herein provided, deputy commissioner may eject any person from land over which no person has acquired the right of a proprietor, landholder or settlement holder. The person is the deputy commissioner, my lord.
Where is the impugn order?
Impugn order is the, my lord, circle officer. Page, my lord, I have shown, my lord. 96, my lord. As the eligible circle officer.
96?
96.
Where it is?
Annexure 19 Kohli, my lord, my page 96. Yes. Issued by the circle officer. Below.
96 is something different.
96, my lord. 96.
96. Yes.
Yes, my lord.
96 is something, copy of the Kabula application.
My lord, your lordship has taken my lord, item number 32 or 31. I am 32.
31.
I am 33. 31 sir.
It's the same area or what?
Same area. Same area.
97. Dog number 97.
97.
Dog number 97.
Yes.
So we'll dispose of let the deputy commissioner issue a notice after hearing.
My lord, what has happened? Lordship may kindly take up our affidavit, huh? My lord, if lordship.
And also, my lord, Withdrawal pattern was not followed. Next as justice.
No, this the notice was issued. That's why. Where is the notice? I just wanted.
Yes, my lord, in page 96 on my petition, ma'am. Item number 32, page 96.
Jatin Talukdar.
Yes, my lord.
Circle of One.
Circle.
The office is hereby again informed you the as per order passed in demonstration by the Honorable Guwahati High Court and passed by the state it was suggested. Where is this order? 3715.
Yes, my lord. Lordship, kindly page 96, the 1376, my petition number. And
No, this annexer what 19?
19 Kohli.
Huh.
Yes, my lord.
This is?
This is issued by circle officer.
Huh. You are agreed by this?
I am agreed by this notice.
So whatever this writ petition 7315/2020?
Yes, that order starts, my lord, at page 45.
No, no, no,
My lord, my senior colleague will address, my lord. Let him.
Yes, there is an order, my lord.
45.
Yes, my lord.
Yes. Yes.
Page, my lord. 94. Disposal of an instant basis of writ petition with the observation. I will also got it in my petition, madam. Page 94. Impugn notice rule 18 so as to issue petition vacate the constituted notice issued by the circular evidence to suppose why should not be evicted rule 18. The petitioner and the writ petition are given liberty individual reply substantiating document and deem proper thereby cause benefit right the claim. Occupation, so because the liberty executive 30 days notice, then my lord deputy is directly given opportunity of hearing either personally or through the then my lord substitute come to the dead my lord. As an appropriate order, the deputy commissioner is further allowed to particular area wherein such situation may hang in the notice of which deputy commissioner indicating the area. This could find that direct there. Upon speaking order being passed, the deputy commissioner shall notify his notice board of the fact of the speaking order has been passed for a period notification. No coercive measure has been taken. Agreed with this. As per rule 18(1), my lord, it is the deputy commissioner who shall exercise the power, my lord. Because he has a right to, my lord, evict the person. That is the Honorable Justice S. Medhi took this, my lord, passed that order. Circular officer knows that he has fairly considered in that case. He has considered that a circular officer has no power to issue the notice.
Who?
He, my lord, respondent authority. I am again.
So what happened to this?
That, my lord, disposed of now. That paper has been disposed of, my lord. I was not still evicted in 96, my lord. They have anything process about this, no? We are not given. We are not given 96, madam. Till now, we are not given any eviction of 96. Subject to correction. Is it there, no?
96?
Yes, my lord. Tag number 96. And this is petition. Where is my lord?
This is?
This is 97, my lord.
97.
Yes.
Yours is 96.
This is 97.
Earlier 96, I also appeared. In 96, I categorically submitted before your lordship is that, my lord, as per rule 18.1, it should be exercised by the circle officer. Then, my lord, he also considered that, sorry, my lord, my lord, rule 18 should be issued by the deputy commissioner. He also considered that notice of the deputy commissioner is necessary, my lord. Then, my lord, the impugn notice which has been issued by the circle officer set aside, my lord, and directed to issue fresh notice in respect of 96. My lord, in respect of 97, same thing has been done.
No, what I'm saying is this order dated 07/11/24, certain direction was issued.
Yes,
What
my lord.
happened to that?
To their happen, my lord, nothing has been done. So far, my client is concerned, no notice has been received. One day they have said, you within the 3 days, you shall be evicted from the place, my lord. No speaking order passed, nothing, my lord. They have passed this order.
You are not party to this.
My lord.
Were you a party to this?
No. We are same footing, my lord. That is why I am selling same DAG number, my lord, 97. There are some petition on 97. This direction has been given, my lord. So, rule is as per division bench judgment, Salekuddin, my lord. You have to give odioldum pattern. I am showing your lordship, my lord.
It's okay, it's not required.
Yes, my lord.
Yes. We'll pass the similar order. You consider, let the deputy commissioner issue a notice. After hearing them, you pass the speaking order, evict them. That's all.
Oh, my lord, that is it. This is a case of oath versus oath. On oath, they have stated in their writ petition that they have not been evicted. We are contemplating to evict them. And in our affidavit, we have categorically stated that they have already been evicted. So the dispute has arisen. Under that circumstances, this honorable court, on the last occasion, made a pointed query to my learned colleague to satisfy this honorable court that the dispute being apparent on the face of the record, you kindly satisfy how can a writ court exercising jurisdiction under 226 without adducement of any evidence can, my lord, come to a conclusion whether they are evicted or not.
We'll not go into the whether they are evicted or not.
Okay.
Right? We're into the issuance of notice. As per the rule 18, it is to the adjournment has to be by the, it is as per rule 18.
It is as per rule 18.
So it has to be by the deputy commissioner.
It was required to be done by the deputy commissioner. There was an amendment carried out in the year 2010, whereby that power has been delegated to the circle officer. My learned colleague, senior friend, has not brought it to the notice of this honorable court. Now,
well, I have hesitated, my lord. He has, dear my lord, fairly considered this thing. He said, now he's blaming to me, my lord. Always he come one after, whether in the affidavit they have said all these things.
Where is this amendment?
Yes, my lord.
If it's already amended, can't help it out.
But
give me the print out copy.
my lord, I have already mailed, my lord, it has not gone, my lord, somehow.
Mail it. Get it printed.
I have to get the copy, my lord.
No, whatever. Eviction and not eviction, that issue will not enter into it. If you are evicted, evicted. If you are not evicted, if it's not evicted,
Yes.
we'll just dispose of the matter.
Yes.
In view of the similar matter being disposed of with a certain direction. We'll just say that
Yes, my lord.
provide them an opportunity.
Yes, my lord. I see, only give them opportunity, my lord.
If they have been evicted.
My lord.
I'm not
Will the
concerned.
status quo as on to the settlement then?
If not evicted, not evicted.
Yes, my lord.
But provide them a notice because as per their claim, their case for settlement, what is called, it's a settlement or what?
Settlement, my lord. I am asking for settlement. Similarly, person has been settled, just adjacent on my pair, my lord, and they have issued patta to that person. In that, they have said 97 DAG is not belongs to the EV hospital. Now they has.
No, we'll not go into that.
Yes,
That
my
all these things
Yes, my
will
lord.
be decided by the
Yes, my lord.
deputy commissioner.
Yes, my lord.
Deputy commissioner or who? Who will decide?
Deputy commissioner, my lord.
Deputy commissioner. But here is
So we'll not will not say that, will not discuss about the competency of the circle officer also. If it is amended, notice can be issued by the national, no issue. We'll just say that since you have not been heard
Yes, my lord.
on the basis of the order of this court in
Yes, my lord.
other similarly cases, you have been directed to vacate, right? What is the, let's see, 90, 96?
96.
96.
No, I was to 96 of me.
Yes, this is as per order dated so and so, by the Honorable High Court so and so, issued by District Commission, it was notified you to vacate the land within 15. They are not a party in this writ petition.
Yes, my lord.
Earlier
Yes,
decision.
no party. 96 is not party.
3715, they were not a party here.
Yes, sir.
There is a my lord twist, which I will point it out.
Yeah.
Because here,
Yes.
my lord, initially there were large number of cases, my lord. Almost 32 matters were there. Now, amongst that batch of writ petition, my lord, a category of cases was such, my lord, where the writ petitioners therein are still residents deciding. And they were party, my lord, to that litigation, my lord, which lordship has just now seen. 2715. That is the difficulty, my lord. I need a protection, my lord.
Yes.
Otherwise, I cannot submit, my lord, fairly.
My lord, we are fighting for 10 visa of land, not my lord. That mass land, my lord. I am with the weaker section of the lighter section.
I lose control of my flow of thought. Correct. So there are, my lord, that 32 matters. Now, this is the genesis. These people has been litigating since a long time, since for quite some time, my lord. Now, prior also, at prior point of time, some notices were issued, my lord, then they come before this honorable court. Sometimes court interferes, sometimes not. Be that as it may, my lord, finally, this issue has been settled, my lord, by this honorable court by way of that common judgment and order. This is before your, my lord, with all respect. Now, these, my lord, directions appearing at page 94, paragraph 50, this has been issued in pursuance of, my lord, a decision by the division bench of this honorable court pronounced in the case of Salahuddin. My lord, in Salahuddin, it was a reference matter and sent by the single bench of this honorable court to the division bench. Rule 18, which lordship is dealing here in, my lord, provides for ejectment forfeit without there being any contemplation for issuance of any notice and without there being any contemplation in the rule itself for giving a right of hearing. Now, right of hearing. Now, my lord, a issue arose before this honorable court, my lord, while dealing with, my lord, a writ petition pertaining to ejectment, my lord. There, my lord, this honorable court found, my lord, single bench found, my lord, that there are conflict of decisions with regard to, my lord, issuance of notice under Rule 18.2. Now, whether notice, if at all is required to be issued, written notice under 18.2, and whether a right of hearing has to be given, these issues were kept open, my lord. Therefore, the honorable single bench, my lord, referred the matter to the division bench. Division bench has finally disposed it of, my lord, saying, my lord, directing that under Rule 18.2, which provides for eviction from government land, my lord, the notice have to be issued, my lord, in the nature of a show cause. And the person who is in occupation, my lord, maybe, my lord, albeit he may be termed as an encroacher, he has to be given an opportunity to present his case, and more particularly with regard to the aspect, my lord, whether he has any bona fide claim of right over that particular land in question. And after giving him an opportunity of hearing, and after giving him an opportunity to produce all the materials and relevant documents which he may like to produce in his support, the Deputy Commissioner will, my lord, finally pass a speaking order. And thereafter, my lord, after the speaking order is passed, my lord, then thereafter also, my lord, some restrictions are there. Once the speaking order is passed, that has to be communicated to the affected person. And further, my lord, from the date of issuance of that speaking order,
a further time period of 30 days has to be provided, my lord, to the affected person to avail any other further remedy that may be available to him, my lord, under the law. So this is the scheme of eviction which has been settled, my lord, by this honorable court. Now coming to the facts of the present case, my lord, in that repetitions, my lord, the almost 32 matters were there, my lord. There were some category of cases, my lord, where if Lordship is taking up that decision, my lord, Lordship will find it at paragraph 16, my lord, paragraph 16, which printout has just been given, my lord. Whether notice, my lord, the delegation of power. Paragraph 16, my lord. Paragraph 16. So therefore, now this batch of repetition, which originally stood thus, my lord, before this honorable court, comprised of, my lord, 32, my lord, 32 matters, 30 to 32. Now there, my lord, some repetitions were there, my lord, where, my lord, the persons were still in occupation of the government plot of land, and, my lord, they were parties in that repetition, which Lordship is seen, my lord, is the part of the pleading, my lord, that direction, 3715. And therefore, my lord, their repetitions have been segregated. And in pursuance of these directions, my lord, they have participated because here in these matters, my lord, earlier the cycle officer had issued notice. This honorable court said, my lord, that in the meantime, since, my lord, this pronouncement in Salahuddin came, that notice cannot be a notice of ejectment forthwith. It has to be treated as if it is a nature of a so-called. First of all, the authority has to give a, my lord, opportunity. You so-called, why you should not be evicted? Rather saying that go and vacate the land. So this is the distinction that has been called out. Fair, my lord, fair. Now, in those petitions, my lord, notices were issued by the circle officer. Then this honorable court at page 94, where Lordship has just now seen these directions, my lord, this honorable court stated that, okay, fine. Rightly, wrongly, some notices have been issued by the circle officer. Let these notices be treated as notice of show cause. Thereafter, my lord, these directions have followed, my lord. It is to be treated as a notice of show cause. They will have to, they were given an opportunity to participate in the hearing. And in fact, my lord, those writ petitioners, my lord, in those batch of writ petitions, which were originally a part of this batch of writ petition, they have been segregated. Speaking orders have been passed. This honorable court has heard the matters in detail and the judgment is reserved. Because those persons are still in occupation. There, this honorable court is examining the, my lord, legality or otherwise of the speaking orders. Here is a case, my lord, where speaking orders are not there. They have not participated. So this is the difference. And why speaking order is not here, my lord, in this batch of writ petitions, which are originally a part of that batch, my lord, this has been called out. Why? Because we say that you are already evicted. Now, the twist here is, my lord, my lord, in item 31 to 38, these are the writ petitions before this honorable court today. In item 31, my lord, because my learned colleague is my lord, pressing item 32. In item 32, the writ petitioner was not a party in the earlier round of litigation. But in item 31, they were party. So Lordship will kindly mark that, my lord. Item 31, they were already party. Item 35, already party. 36, already party. 37, already party. So they had missed the bus. They did not participate. They were given opportunity to participate. They didn't participate. So they will have to, my lord, face the consequences. So this is how the matter stands, my lord.
Item?
My lord, in item 31, my lord, they were earlier party.
In 371?
Yes, 3715. They were party.
They were a writ petitioner?
Yes.
Repairing party in 31, 37, 38. Yes, Lordship, they were part.
31?
31, and I am representing 31.
31?
my lord, item 31, then 35, then 36, my lord, then 37, and 38.
They were party to the earlier writ
Yes,
petition.
they were.
So you have not participated.
They have not participated.
I'll make my submission, sir. Party, we have submitted our request, your lordship, our cases were not considered.
No, they say that they had submitted, but not within that timeline. They missed the bus, not within that time, because this honorable court at page 94, for my satisfaction, lordship, may kindly see, my lord, page 94 again for a moment, my lord. What were the direct?
Vacate shall be considered notices by the the parties in respect of the given debate shall be.
My lord, Roman 3 is most important, my lord. It assumes, my lord, utmost significance here. The liberty given above is to be exercised within 30 days from the date of the instant orders. In the said replies, the petitioners herein shall indicate in which writ petition the petitioners their parties. Now they have missed that timeline. They have missed that timeline. Then, my lord, Roman 4, Deputy Commissioner, my lord, what is required to do, and Roman 5, my lord, what is further required to do. So all these things are there, my lord. A further 30 days after passing of the speaking order has to be given to the petitioners or the persons affected as, my lord, a breathing period. It will be a breathing space for them.
The speaking order is under challenge.
Yes, in those writ petitions. Here, my lord, we didn't have any opportunity to pass speaking because we had the opportunity to pass the speaking orders in terms of this direction.
So why you are suppose this then why you have issued a notice for vacation or eviction in view of this order, as per this order, when you have not heard them?
So that may be there, my lord. The notice, my lord, it may be worded as such.
We'll have them who are the party to this writ petition.
Yes.
Rest will not go into whether they have been evicted or not. You take your own call. Will direct you to similar order will grant.
No, similar order, my lord, if they are already vacated, then the issue will come whether they can be rehabilitated. We say that they are already.
Just wait. No, it doesn't say anything. The cause that the petitioner have a vulnerable claim involved in respect to land under their and as such the resolution is not permissible. There's nothing. It's just an to hear and pass an appropriate order. Today we are not saying anything.
No, my lord, we will hear.
This court order, upon speaking order being passed, the effort this effect, the speaking order had been passed for a period of 30 days from not even no coercive measures be taken to serve. This we may not. This last and 3 lines we may not. We'll just say till the speaking order is passed, status quo is to the mentionment.
Speaking order, lordship will kindly, because they will have to lay a fresh claim.
Yes.
They will lay their claim afresh. And then, my lord, on the basis of their claim, they will be, my lord, heard. They will be heard.
Yes, this will provide this much of 30 days time. All right.
Absolutely. But at the same time,
since they have been already affected, if we pass the status quo,
no, lordship would be.
When they were evicted?
Yes, we have categorically stated on 7-3, notices were issued on 5-3. Kindly come, my lord.
So once it is evicted, if we pass an status quo, what is the problem?
That is my respectful submission. They are helping for status quo order. I say, therefore, at the initial, very beginning of my submission, my lord, with all respect, I have clearly stated that this is a classic case of oath versus oath. So therefore, my lord, this honorable court, while hearing this batch of writ petitions on the last occasion, my lord had asked the petitioner side to satisfy this honorable court. Because this honorable.
No, that's why we're not going to all this disputed will not say.
My humble submission before your lordship. Why is worried about the status quo order? He knows I was not evicted from the place because I also reply said I was.
Suppose if we pass a status quo order today, if they have already evicted, then
that is the thing. Therefore, my lord, this land is reserved for TB hospital, and the TB hospital is under the second medical college is coming up there. It is
Sir,
under
if
construction.
you are saying that they have already been evicted.
They have already been evicted. Government is going on full swing, my lord, for construction of the medical college.
So
Now, my lord, it's status
so what
quo.
status order will?
Absolutely wrong statement. They have given settlement, my lord. I can show. Same doc, my lord. I said, this is not belong to, I am not going to merit of this case, my lord. I am only that notice for me.
Now, my lord, status quo order is, my lord, passed by this honorable court. Then government would be in a difficult position to carry, my lord, continue with its construction.
No, we'll make it clear. See, status quo is on today. But so far as the construction is concerned, it should proceed with. Construction should proceed with. You are saying,
Yes. The funny thing is that let them show to the project, other thing, nothing is there, my lord.
if the construction is going on, we'll allow it to continue. So no, the status quo orders shall not be come in the way of construction.
Lordship will kindly appreciate, my lord.
So they are affidavit.
See, you have said that clearly. You have said we have evicted them, although they are trying to say they have not evicted. Once they have evicted, matter is there.
Therefore, my lord, what would be the necessity, my lord, of allowing them to file their representation afresh? What would be the outcome? It will be an infructuous exercise. It will be a redundant exercise. That is my submission, my lord.
No. Suppose you have no, without hearing them, then we'll interpret the eviction.
My lord.
We'll interpret the eviction in that case.
Therefore, my lord, my lord, we say that they are already evicted. Now, lordship, will this honorable court, my lord, pass a order of...
No, you have not considered their case, and how can you evict them?
Hello?
You have not considered their case.
My lord, they have missed the timeline. How can we, my lord?
What about 32? Item 32.
So therefore, lordship will kindly restrict that order, my lord, only with regard to 32 and 33. 32 and 30, yes, 32 and 33. Because they will have to, they had gained an advantage from this order. It's a constitutional court's order, my lord. They slept over this order, my lord. They missed the bus deliberately.
32 and 33.
Yes. So only
1, 2, 3, 4, 5, 6,
yes,
7.
only with regard to 32 and 33, my lord, lordship may direct, my lord, that they may be given a liberty, my lord, to find their representation.
32 and 33.
Yes.
How many matters? 8 matters. 8 matters.
Yes, my lord, only, yes, 8 matters, from 31 to 38. Yes, out of, my lord, these 8 matters, only in 3 matters, my lord, that is item 32, 33, 34. Lordship may be pleased to, my lord, grant them the liberty to file representation afresh, and, my lord, the authority will take a call, my lord.
Yes.
And so far as, my lord, these other items, my lord, 31, 35, 36, 37, 38, these petitions are liable to be dismissed. How can I help, my lord? How can I help? Every time this honorable court.
As per judgment, petition number 3715, dated 7/11/2024. But after some
on the medical ground, we could not submit the representation in due time, my lord. After 10-15 days, we have submitted, but we have not called for hearing, my lord.
So if I take
35 and 36, my lord, I am submitting.
They could have.
We have filed representation, my lord. We have record, my lord.
What record?
Representation.
You are party to the writ petition.
Yes,
certain direction were passed.
Yes, my
You
lord.
have missed the timeline.
Yes, ma'am.
How can we help?
That is the reason, my lord.
Then also, my lord, with all respect, then also I can understand that he may have a genuine, my lord, difficulty. He could have filed a, my lord, interlocutory application seeking further time, my lord, in terms of this order. That is not done. Straight away he files a writ petition. Because a fresh read petition means a fresh cause of action. So you are here with a fresh cause of action. Is it the case of the petitioner that he has waived, my lord, his right, accruing under from this order, my lord, flowing from this order? Is it their case, my lord? So therefore, my lord, item, my lord, with all respect, my lord, item, my
Item
lord,
32, 33, 34. You're
Yes.
right. We'll hear you after this.
Move to pass.
Heard Mr. NNB Chaudhary, learned counsel for the petitioner. You are in item
32, I'm 32. 30,
33 and 34, my.
32.
31, 31.
And in writ petition WPC 1378 of 20.
1376, my.
1376. And Mr.
1459.
And Mr.
A. Motley.
Then is counsel for writ petition. One four
59 and 1462.
WPC 1462.
1459 and 1462.
Yes, of 2020. And Mr. Arbor Pujari, learned counsel, learned standing counsel, revenue. And Sir Borwa,
Correspondent number 2, 3, and 4.
correspondent number. Hmm?
3 and 4 also. In item number
2, 3, and 4. By filing this writ petition, the petitioners, how many? 5.
5, I think.
Yours is 5?
In my case, my love, 5 petition.
5 and
দেখানো ইয়াতে নচলে।
rest?
591. And 1462.
Single. 7 in numbers. Have
yes, ma'am.
challenge the impugn order, challenge the notice dated 05/03/2025. Same date, different date,
In my case, all are same. Man.
same date. Notice is, date of notice is same.
Same, 5K, same.
Issued by the circle officer, Guwahati Revenue Circle, Guwahati. Whereby the petitioners are directed to vacate the encroached, vacate the land or else otherwise eviction drive shall be carried out in terms of the order dated 21/11/2024 passed in WPC number 3715 of 2020. Mr. Next paragraph. The brief facts of the case is that the petitioners are the residents of village Ulubari within bracket Birubari bracket close Dr. B.R. Ambedkar Nagar, Guwahati, under Ulubari Moja, and were originally inhabitants of different districts in Assam. List of they occupied a portion of government land measuring government land at dock number 12, within bracket old, 97, within bracket new, and have been residing. All of them are dock number
97.
97.
Yes.
97 and new. All of
Yes,
you
sir.
also.
97 new, 12
By
old.
constructing dwelling houses thereon since last 25 to 30 years. Next para. The petitioner submitted application before the respondent authorities, particularly Deputy Commissioner Kamrup within bracket M bracket close, for settlement of the land in question in favor of the petitioner. However, the list of instead of considering the case of the petitioner, the impute notices have been issued. Impute notice 0503.
Yes.
03 has been issued, directing the petitioner to vacate the land in as per the order passed in WPC 3715 of 2020, dated 21/11/2024. Mr. NNB Chaudhary, Learned Counsel for the and Mr. So-and-so, Learned Counsel for the petitioners, submits them under what is this regulation?
My lord, this is the my lord.
The submits the
Settlement rules, my lord. Rules under the Land and Revenue Regulation, Part 2, my lord. Settlement
land
rules.
policy.
Yes, my lord.
Land policy also there.
Yes, my lord. Land policy and also the other.
Submits that the
My lord, it is rule, my lord, I beg apology, but it is rule 18, my lord, under the rules, my lord, can you see it, my lord? Yes, yes.
no.
Assam Land and Revenue Regulation 1886.
Simply take up the land revenue manual, my lord. Yes, yes. Go to the 5%. Rule
Assam Land and Revenue Regulation 1886.
More book দিব এফালে মই দি দিছো মই মাৰ্ক কৰি দিয়ে মই মাৰ্ক কৰি দিম
But this notice is not under Rule 18.
Yes, rule 18.
Notice is not under Rule 18.
It may not have been spelled as such, my lord, but it is notice under rule 18 because that is the only provision, my lord.
No, that it's here,
Yes, ma'am.
but then under what rule, what provision they are entitled for settlement? Settlement of the land.
Settlement of the land, yes, that is under Rule 5.
Rule
Of that
5 or
rule.
Rule
Yes,
10?
Rule 5. Possible kindly see Rule 5. They are not entitled, but their applications can be considered. One may file an application for settlement of land. Rule 5.
Application for land.
Yes, there.
Leases of wasteland
also
shall
land
be in
policy-
writing and shall be presented to the officers. Should be made in.
Rule 5, Rule 6, my lord, Rule 7, Rule 8. All these rules are there, my lord.
You have made an application. You have filed an application for settlement. Okay. We'll say submits that as per the Assam Land Revenue Regulation, the petitioners having been settled, having been in possession, occupation of the land in question, are entitled to be considered for settlement. The Rule 2 is the power.
My lord?
Power to settle, power of the deputy commissioner is Rule 2.
Yes, Rule 2 is the
Rule 2.
These are the dealing provisions, my lord. These are the dealing provisions, my lord, with general application. But the particular rule starts, my lord, from Rule 5. And precisely, my lord, submitting, my lord, it will be, my lord, from Rule 5 to Rule 8. The procedure is called out there, my lord. If they are in occupation, my lord, if they are in occupation.
So we'll not go into the competency of the circle officer, because as per the amendment 2010, circle officer has been delegated.
My lord, my lord, my lord.
My humble submission before your lordship is there. That is not the part of the pleading.
No, it's okay.
And-
We'll not
and
go into,
this-
when it is a fact, fact
Yes,
is
sir.
fact.
And another thing is that.
We take cognizance of it. We are
My
taking cognizance of it. All right.
lord, we are not hard of this, my lord.
Hmm.
That part, no speaking order has been passed. So far, my case is concerned, no notice has been issued.
The learning council for the parties, petitioners submits that although the notice, impute notice dated 05/03/2025 does not specifically indicated under which provisions of law, which provisions of law the notices have been issued. However, considering the Rule 18 of the settlement rules, it is the deputy commissioner who has to issue ejectment notice, who has the authority to eject the
My lord, there is a-
encroachers
Yes.
from the government land. List of the petitioners having accrued right for settlement over the land in question, which are under the occupation, not only as per the land settlement rules, but also the land policy of 2009, 19, huh? The case of the petitioner is maybe directed to consider list of the the NNB Chaudhry Land Council, while relying on the order of this court, judgment and order of this court, passed in order of this court dated 07/11/2024, passed in a batch of writ petition, the leading case being, where's the first number of so many writ petition? This is the first case.
First case, my lord.
Leading case being writ petition 3715 of 2020, within bracket, Monmil Borough and others versus State of Assam and others, submits that, and the similar, the submits that this court has, in a similar circumstance, matters have has held that the question as to whether the petitioners can be acquitted by following the summary procedure as to whether the is mandated under Rule 18 of the settlement rules is dependent upon the decision as to whether the petitioners have a bona fide claim of right involved. And also taking note of the land policy of 2019, which stipulates that an indigenous person having no land would be considered for grant of settlement, subject to person showing that he or she fulfills the condition as per the Assam Land Policy 2019. Cannot be, the persons cannot be evicted by recourse to the summary proceedings without affording an opportunity of hearing. Just accordingly. Directed the respondent authorities to allow the petitioners in those batch of writ petitions to submit individual replies and replies treating the Rule 18 notice, Rule 18 of settlement rules notice as a so-called notice, with a further direction to the Deputy Commissioner, Kamrup Metro, within bracket, to provide an opportunity of hearing to the petitioner, either personally or through their authorized representatives, and to pass speaking orders. Therefore, he submits that the petitioners are also similarly situated person as those writ petitioners were have claimed to have settled in DAG number 97. Yours is 96.
Earlier was 96, order has been passed 96.
Or 96.
Yes, so,
96.
that is 97.
And the petitioners herein are under DAG number 97. Listen. So, then three writ petition, what is your submission? You are fairly admitted they should be given in view of the order of this court.
Absolutely, my lord. But my lord,
Mr. Arbor Pujari, London Standing Council Revenue, and Mr. S.R. Borwa, London State Council have fairly submitted in view of the order dated 7/11/2024 passed in the above first in writ petition, that is 3715 of 2020, and other batch of writ petitions. Which pertains to the DAG number 96.
97.
97.
97.
And the petitioner herein being under DAG number, claimed to be under DAG number 37. Similar order and direction may be passed as passed in the as granted as there is passed in the above batch of writ petitions. That's all. Next.
Only submission that they will lay a fresh representation.
Yes, yes.
Within a definite
We'll
timeline.
do that.
And they will submit a certified copy of my lord's order.
We'll do that, huh?
My lord, my lord. I'm so grateful, my lord.
I've considered the submissions of land council by the parties and also perused the materials available on the court. This court, the petitioners claims to be residing in the claims to have claims to be in occupation land at DAG number 12. No. This is 97. You said your case is 96.
97, I said.
Okay, there were 96.
Yes, my lord.
That is
96.
Therefore, there I had my lord considered on my lord, different facts and circumstances.
Anyway,
Yeah.
but then in view of this,
The court, my lord.
we'll not go into all this thing. Eh?
Therefore, my lord, therefore.
Even we're not saying whether this thing circle officer has the authority or not. Or should I say?
Yeah, your lordship say because land policy I have just now got 2009, only deputy commissioner has power.
My lord, I will withdraw my concession because I will have to resist that. So that submission is not.
Well, wrongly or rightly, that has been decided in this case. In view of this, in other method, the competency has been decided here.
Yes, ma'am.
So we'll not go into this. Why we should reopen that again and again? All right.
The amendment also, my lord. It has been amended.
Aims to be in occupation of the plot of land under DAG number At Doug number 97, 12 within bracket all the or 97 within bracket new. Are you getting me? What I say? Getting? Since 25 to 30 years, this time, they have further claim to, and they further they have claimed to have filed application for settlement of the land in their favor as per the land policy 2019 as well as the land settlement rules. List of as submitted by the as stated at the bar. No. This court in a similar matter pertains to Doug number 96. Has disposed of the batch of writ petitions by an order dated 7/11/2024. The leading case being WPC 37. What is the same, huh? That one.
Yes, sir.
3715 of 2020. The relevant paragraphs are quoted here in below. Here are 48, page 92. 48, 49, 50, up to last. 48, 49, 50. Next paragraph. Having considered the submissions of learned counsel for the parties, and also considered that this court has disposed of the similar nature of matters being WPC, leading case being WPC 73715 of 2020. You write the name, within bracket you write, huh? Then this is within bracket supra, huh? And considering that the present petitioners are also appears to be similarly situated, similarly circumstanced. I am of the considered view that similar relief can be granted, similar relief may be. The petitioner is entitled to the similar relief as the impugn eviction notice directing the petitioner's vacate appears to be without providing any opportunity of hearing. Just accordingly, a similar relief is provided to the petitioners. And the writ petitions are disposed of with the following observation and direction. Huh? Page 94. Paragraph 50, page 94. We'll just modify this. We'll save the time. We'll just modify this. We'll follow the direction. You right? The petitioners are directed to submit individual. We'll direct them.
Yes, individual.
Directed to submit individual representation with documents of evidence in support of their claim that they are the bona fide claim of right involved in the right over the land under their occupation for settlement as per the land policy and land settlement rules. The next, huh? No, then within a period of 30 days, we'll provide 30 days filing the application.
Yes, from today.
Within 30 days from today, you'll get the order in the evening. Then before the deputy commissioner, we'll say directly deputy commissioner.
Absolutely.
Deputy commissioner Kamrup, Kamrup Metro within bracket M, Assam, the deputy commissioner on receipt of the application shall provide the petitioners by shall afford an opportunity of hearing to the petitioner. We'll say same,
Speaking order.
No.
Yes, Father.
Petitioners.
Either by himself or by his delegate.
Okay, then either personally or through their authorized representatives. Same,
Same.
And the deputy commissioner shall, after providing an opportunity of hearing, shall pass appropriate speaking order. List of thereafter the petition shall be communicated with the speaking orders within a further period of 30 days
3 days.
from the date of submission of from the date of receipt of the application.
Yes, Father. From
Application.
the date of receive the application.
They will lay their applications within 30 days from today, my lord. And once their applications are received, my lord, the deputy commissioner will dispose of their applications within the next period of 30 days. Yes.
That's why I said within the next period of 30 days.
It will be maximum time limit, my lord. It may be prior to that also, but maximum is 30.
Writ petitions are in this instance disposed of.
My lord, till then status quo as on today shall be maintained. Because, my lord, here said evicted, I said not evicted, my lord. I have a document, my lord. Everything is there, my lord. I can show I was not evicted.
Till the speaking order is passed, status quo urgent today shall be maintained. However, it is made clear that any construction
No, my lord, because
will say
my humble submission before your lordship is
just
that,
wait. You are saying that the construction,
Construction activities, everything is going on. If lordship may be pleased only to record that this much, my lord, then if they are not evicted, because we say evicted, they say not evicted. If they are not evicted, that much will do, my lord. They will be protected. If they are not evicted.
if they are not
If they are, if they
status
are not
quo.
evicted.
Please, I will say, however,
However,
however, any construction for what hospital,
It is any construction for the second medical college,
second medical
college.
shall not be disturbed.
my humble submission.
Or there no, we'll say, however, the order of status quo shall not be construed as an construed as a bar to disturb the any construction for second medical college, which is stated to be in progress.
My humble submission before Lordship is, and in their affidavit, nowhere is stated. In fact, the land was not given to this TV. No proposal, nothing is there. If your Lordship state these things, my lord, tomorrow they will come, my lord, and say.
Part of our affidavit.
That's why is that. Let them show the construction is going on. Let them show, my lord.
It is a part of our affidavit.
No, my lord.
Yes, yes, show it.
Yes, yes.
But medical college, it is there. Then
Yes, sir. I'm reading their affidavit.
Just read it. Just read it, Mr. Borpujari.
What, my lord?
That the construction is going underway.
That is not there. That
is submitting, my lord.
No, my lord, why I have made that submission? Because he is picking up photographs one after another. This is also not there.
Okay, I'll
No,
we believe all the learned counsel, the submissions where we take note of it. All right.
My lord,
yes.
my humble submission before your lordship is there.
Public
Affidavit is not there. What they will done, my lord? Tomorrow they will come. That in the gap of medical college, my lord, our house shall be. They will be. House shall be evicted, my lord.
No,
they
no,
will take
they will not be evicted. You see, you record
because in their affidavit, I am reading, my lord. They only say that they are evicted the person. Nowhere says the construction is there, because my understanding is that my instruction.
Okay, sir.
Proposal has been taken.
Okay.
Not a proposal has been taken.
See, if you are not evicted, you will not be evicted.
Yes, my lord. And other
Status quo. And so far as the construction were not inclined to disturb it.
Construction, my lord, no proposal. Tender was not the is there no proposal.
That's why I said.
Yes, my lord.
Any construction we said, if there's no construction matter.
But if any, my lord, if any.
That's why any construction I said.
If any tender, that.
No, that will not go into.
But my lord, nothing is there. That is why I.
Yes, other cases.
Yes, my
lord.
My personal house is not being constructed there. It is for public.
Yes, that too medical. Yes, it's okay.
Submission is that, my lord. For 10 lesser land, they are fighting, my lord. And for other, I should not submit, my lord.
Yes.
They should think.
That's the reason.
And they get settlement on the same time. If a lordship go to the.
Yes. It's we'll not go into all these things.
Yes, my lord.
I'm so obliged.
Yes, other this.
Other, my lord, item 31, my.
I am in item number 31, 37, and 38.
35 and 36.
Okay. Heard Mr. So-and-so learned counsel for petition and writ petition. Writ petition.
1439.
This 31.
1439, your lordship.
And
1502.
yes. You are in 2 writ petition.
Yes.
You are in.
I'm in 3 writ petitions.
3 reasons. Then you just tell. Writ petition 1439 of 2025.
2141 of 2025.
Yes.
And 2147 of 2025.
Yes.
I'm on 3 writ petitions, your lordship.
And Mr.
One is 1502 2025.
Yes.
And another is 1533 2024.
Yes. And Mr. Please, and also heard Mr. Arbor Pujari Then standing counsel for revenue department. For respondent number?
Respondent number
So and so, you
one.
find out what for me.
For 3 and 4.
And Mr. S.R. Borwa for 1, 2, and
He is for 1
I am
and
for-
for 2, 3 and 4.
you are, there are
Yes,
4
sir.
respondents only.
Yes, yes. 4 respondents.
One and this
2, 3 and
state council for respondent number
2, 3 and 4.
2, 3, and 4. Huh?
My lord.
So what is to be done here? You consider, although they have missed the bus, consider it.
No, they could have filed, because this is the, my lord, order passed by a court of law, by this honorable court, upon hearing that. It is not that, my lord, this is an expert.
Yes.
Upon hearing.
But there's an order. You are the party to those batch of writ petition.
Yes, my lord. Due to medical.
So
grounds,
you
we
have-
not filed representation in due time, my lord, but later on we have filed. We were not called for hearing only.
Huh?
We were not called for hearing.
No, when you have not done within a specific, within a time limit
It is not now
or
possible
timeline, you,
because
how can you insist that you had not been heard? You could have tell them that it was a 30 days.
Sir, we have written, my lord,
When?
to DC, my lord,
Where you have written?
that due to some medical ground we cannot submit.
After?
Yes.
After the expiry of 30 days?
Yes, yes.
After the expiry, we can do, what can we do?
My lord, there may be a way out, my lord.
Yes, just suggest.
I always, my lord,
These are facts are not
Yes,
disputed. Yes.
there may be a way out.
Ah.
Let them make an application,
Ah.
my lord, for modification of this order. Thereafter, they may come up before this honorable court. Lordship may be pleased to keep these petitions alive, my lord, for some time. Well, they are already evicted, we say. They have not complied. But when Lordship will kindly appreciate, when it comes to the state for non-compliance, the sword looms over us. And when it comes to the
Damocles
compliance-
sword.
Yes, my lord. And
You
when
think
comes-
about it.
Kindly,
We'll take it up next week.
Kindly, for that. my
You
lord.
think about it.
For that, for
All
that.
right.
Otherwise,
Ah.
always they are my lord to help them out.
As
It's not that.
you also think about it. It's just a consideration
Absolutely.
because they said, let us have some faith on them that because of the medical ground. We'll record that. So next week,
Next week, yes.
any date, you just tell us.
My lord, can it be, my lord, on
Similar order we may pass,
Yes, yes,
except
my-
recording your, the non-adherence to this course timeline. And having considered that you have been, you due to medical problem, you could not file within time, whether it's correct or not, but then
Fine.
as agreed to by learned counsel for the parties, let this matter be listed on
Can be on 19th, my lord, Friday.
19th.
19th.
Possible? Make it 18th.
18th, my lord. Yes, 18, my lord.
18. You think about it.
My lord.
I'm inclined to grant them, have the same consideration.
18, it's some difficulty, my lord. Can it be on 17th or 16th, my lord?
Yes,
I'm
16, make it 16.
16. 16 will be, my lord, next Tuesday, my lord.
Ah.
Tuesday, yes, my lord.
Yes, my lord.
You think about it.
Yeah, absolutely.
Oblige,
My lord, so far as the earlier disposal orders, my lord, which lordship has just now disposed, my lord. My lord, if they are not evicted, my lord.
Said already.
My lord, yes.
No, status quo, when we said stay away, we should say if they are not evicted.
Already stated, my lord, that they are evicted, my lord. They may take, my lord.
No, I have said so, in fact.
If they are
In the
not-
order, I have said so.
My lord.
We'll say
My
whatever I can know.
Till the speaking order is passed, no coercive action will be taken.
That my lord has given them protection, my lord, only that, my lord, that phrase, if not evicted, only that much. But that is not going to prejudice them, my lord.
So we'll not say status quo. No coercion.
Yes, my lord. No
If
cost of
they have
action
not
will be
already
taken.
evicted.
Yes, if they are not already evicted.
Yes, my lord.
Correct?
Yes.
So
No coercive action.
we'll change it to that till the, in that, you tell Mona Lisa, in place of status quo, you said, till the speaking order is passed, no coercive action shall be taken against the petition if they have not already evicted.
Not already been evicted, my lord.
If they have not already been evicted.
Evicted, my lord, my lord, my lord.
Just in place of status quo that you just said. It's your own prayer, huh?
We are always